In view of the foregoing discussions, I'm of the view that even though the evidence of PW1 as an eyewitness to the occurrence is not acceptable, but in view of the evidence of PW2 and PW4, coupled with the medical evidence and the manner in which assault has been made and repeated blows were given to the appellant by the appellant to the deceased, and the impact of such blows as appears from the post-mortem report findings as per Exhibit 6, the London Trial Court has rightly come to the conclusion that the prosecution has successfully able to bring home the charge under Section 302 of IPC against the appellant beyond all reasonable doubt. Accordingly, the appeal being devoid of merit stands dismissed. I agree.
I may be, pardon, Lordship. Jail Criminal Appeal 134 of 2004. The different opinion of the division bench and a matter according to listed honorable judge single judge bench. They already allow the order and
Allow the order
the order already passed the single judge
by the single bench,
Lordship.
third judge.
Lordship.
So that will
Division bench maybe.
no, why division bench? That order becomes final
Fine.
when there is a divergent view by the two judges in a division bench. Matter is referred to the
Honorable
Chief
single
Justice to take the opinion of the
Lordship.
third judge. So accordingly, the matter is referred to the third judge, and whatever the third judge decides, that matter becomes the final. So again, why it will come to the division bench, the same division bench or other division bench? That is final. The third judge decision becomes final.
Sorry.
Yes. He might have accepted one of the judge's view, right? So now that becomes three. So three judge and so two judge bench would prevail. Whatever view he has supported, that view. Yes.
Yes.
Correct.
Pass over item number 18.
Absolutely. Yes. On it. So on, so on. So these people and so on. So, how many appellants are there in this case? এটা উঠা তুমি single na
single.
So he has this is the request by High Court legal and so somebody has to be engaged. So you got any name?
Mr. Beura.
Mr. Akshay Kumar Beura.
Yes.
Have you
Yes,
taken his consent?
Yes, ma'am.
Yes.
Yes.
All right. Peruse the later dated a report dated 8/1/2024 of the inspector in charge of Rajgangpur Police Station, wherein it is mentioned that the appellant was contacted in person and he stated that he wanted uh, an advocate from the High Court Legal Services Committee to be appointed to represent him to defend his case during the hearing of JCRLA number 126 of 2005. Akshay Kumar Behra, advocate. So how many years of practice he has?
30, above 30 years.
Who has 30 years of practice, having experience in criminal law side and was the additional standing counsel.
Once.
Once is engaged as amicus curiae to conduct the case on behalf of the appellant. Let a copy of the paper book available achi. Let a copy of the paper book be supplied to Mr. Devra by Wednesday porchu
Yes.
by Wednesday. Matter be listed in the week commencing from 29th of January 2024. Name of Mr. Devra will be reflected. The names of Mr. Prakash Kumar Naik, B Party, BL Party, N Party shall not be reflected in the positive transcript. The status, this report is taken on record for the. Yeah. In the top of the list, top of the positive. I'll delete one the homework. Yes. Guilty radiation.
Item 21.
21, my lord. It is. I will pay your lordship before entering into the case records. Your lordship may kindly have a glance. 2 pages note of 2 pages note. Your lordship may kindly have a glance before entering into record, so that it will be help me while addressing your lordship. So, Mitra, you will argue this case?
My lords.
Did you hand over the copy of it to this?
Yes.
Yeah.
May I start?
Yes, yes.
Lordship, may kindly come to my note.
Oh.
The FIR part which I have narrated. It is the wife of the deceased has lodged the FIR who was examined as PW1, my lord. The FIR story says, in the intervening night of 8/3/2003 and 9/3/2003, my husband, Pavitra Kumar Das, the deceased, went to sleep on the roof by locking the main entrance of the house. I found him dead, lying in pool of blood in the next morning on the roof, with cut injuries below his left ear and neck. I jumped from the roof, and villagers had to break open the door to enter and rescue the inmates. I suspect Pratap Puri, the present appellant, or Sumanta Rao, not an accused here, to have committed the murder due to previous enmity. The sum and substance of the FIR, my lord, was that while the deceased was sleeping in the roof, after locking the main door, someone entered inside and committed his murder. Defense plea is one of the denial, and his specific plea is that one Sumanta Raut, who has got visiting terms to the house of the deceased, had an extramarital affair with the wife of the deceased. Hence, there was every possibility of Sumanta killing the deceased due to previous enmity. This is the defense plea, my lord. Now, the entire case rests on, my lord, circumstantial evidence, and the circumstances relied on by the learned court below, my lord. In the page 3, last part of my note, my lord. Accused has prior enmity with the deceased in connection with theft of a motor, as stated by PW 1, 2, and 3. The next circumstance, my lord. Accused, your lordship got? Accused made a confessional statement and or discovery statement that led to discovery of a sword, which is MO1 and stated by PW 9 and 14.
This is how many days after the occurrence?
My lord,
This recovery was made
after 9 days.
27.
After 9
What is
days.
the date of that?
No, sorry.
You have
9
mentioned
days.
in the first page that the date of occurrence is the intervening night
My lord.
of 8 and 9.
Okay.
So when that statement was made and in consequence of such statement, the sword was recovered. I will look at the evidence of the IO.
My lord.
And
No, sorry.
On 22/6/2003, Your Lordship, page 69 at paragraph 7.
22/6/2003.
3, my lords.
So it is almost
Paragraph 7 of the IOS.
okay.
On 22/6.
After 13 days,
With
my
the IO PW
PW 14.
PW 14 IO paragraph kete kହୁchanti?
7.
7.
7.
It's almost 3 months.
3 months.
22/7. 8, 9, 3, 2003.
ଆପଣ ଘଟଣା କେବେ ଲାଗି?
13 days, my lords.
9, 8, 3, 2003.
3 ହଁ 3 ହେଲେ ହେଇଯିବ ହଁ 3. It is more than 3 months.
Again.
Mr. Mishra, it is
Lordship.
occurrence is March ମାସରେ
9,
8, 9 ରାତିରେ ହେଇଛି ଆଉ ଇଏ recovery ହେଇଛି ଜୁନ ମାସରେ 22. Yes, next.
My lord. Accused made a confessional statement and a discovery statement that led to discovery of a sword. Next, my lord, FSL report suggests that there was a faint blood stain on the sword. And fourth is, hair stuck in the right palm of the deceased was chemically examined and found to be matching with that of the appellant. Now, your lordship may kindly come to the FIR.
Have you? This is the report of
Again.
the FSL.
Again.
Matching with this one. So
but something is there, my lord. I will be coming.
Something is what actually it cannot be said that the hair of a person is this hair. It can be said that this is not the hair of that person. It cannot. That is the difference.
FSL. Your lordship is right.
That hair comparison, it can be said that whether this hair is not of that person, but it cannot be said that it is that it's not a LTI or something like that.
The report is that the exact term used, it's tallied with the sample, my lord.
But whether it is
so
human hair or not, no opinion. It is in page 81, your lord.
Just the reverse thing.
Page 81, it is there. Against item number 7, serial number 7, 2 strands of hair.
Who has stated about the recovery of hair from the right palm of the deceased?
PW2
You
says
have not mentioned any evidence of this on this aspect. Oral evidence.
PW has stated, and he has
Who has
stated
stated? First, tell me
Milord,
about the recovery of
hair.
from the right palm of the deceased.
It is PW2, Milord.
PW2.
Again.
Who is he? And
He is
the
the
witness.
no post occurrence. Brother of elder father of the deceased.
Okay, he was related to.
Again.
The IO must have also stated about that.
Again.
IO is PW 40. And what is that seizure list of that hair?
Seizure list of the hair is, Milord.
Is exhibit
2. That hair part, Milord.
ये पता लो जो हमारा मोदी jurisprudence. So there is no last scene.
No.
No extrajudicial
No, Milord.
confession. And what is the motive behind the commission about that?
That a motor was the appellant has committed theft of a motor, which was subsequently recovered from him. So he had threatened that I will.
जो ए विषय 1 2 3 जो कहुचंदी
motive
theft of a motor of this deceased by the appellant. When that occurrence took place, that theft occurrence, whether any
2 or 3 days, 2 or 3 days
prior to the occurrence,
specific date they nani, it's 2 or 3 days.
Any FIR was lost?
No.
Then how they say that it is the appellant who has committed the theft? They were suspecting or what?
Suspecting. ତାପରେ ସେ ମାନିଛି ବୋଲି କହୁଛନ୍ତି, ମାନିକି ତାକୁ ଦେଇଦେଲା ବୋଲି କହୁଛନ୍ତି.
Okay. Oh, suspected, and it was recovered from the appellant.
Recover ହେଲାନି. It was not recover.
ଆଉ କଣ?
ସିଏ ନେଇଛି ବୋଲି ଇଏ କହୁଛି.
ଓହୋ, ମୁଁ ଆପଣଙ୍କୁ ପଚାରୁଛି ଯାହା ଟିକେ କୁହନ୍ତୁ. You said that that theft took place 2 to 3 days prior to this occurrence. No FIR was lodged. The appellant was suspected of having committed theft. Next query is that whether it was recovered prior to that, or how they came to know, or it was just a mere suspicion.
It is suspicion.
So prior to that, there was nothing was recovered.
No.
So any kind of challenge was made to the appellant in that respect, so that he threatened him. And if the challenge has been made, who has made and how?
ସେଇଟା ଜଣା ପଡୁନି ଆଦକୁ.
threaten କଲା ବୋଲି କିଏ କହୁଛନ୍ତି ଆପଣ?
The wife coach. Wife coach.
Wife କେତେ?
PW1.
Appellant threatened.
In fact, Your Lordship, the statement of PW 2 and 3 is that the theft occurred 2 months ago.
Achha, not 2 days.
Lordship, PW 2 has stated 2 months ago, and PW 3 has stated 1 month ago.
Okay.
And he says that 2-3 days before.
Ki?
Milord, wife.
PW1 says 2 to 3 days prior to the occurrence.
Court felt that there is no commission of the offence.
He has stated that 2 to 3 days ago of the occurrence, the father of the accused had returned the motor through my uncle-in-law. ମାନେ ଦି ମାସ ଆଗରୁ ଚୋରି ହେଇଥିଲା, 2-3 ଦିନ ପୂର୍ବରୁ the father of the accused returned it through
Father of
and he refused to return.
that is where that sword was lying.
Jamujori.
Hmm?
Jamujori PW9. Inside a bush, the accused showed us the way and told us to stop the
All right,
vehicle.
let us place the evidence.
Miller.
Come.
PW1. Page 31.
Yes, please play. 31.
Page 31, PW1.
No, first FI.
Page 22, Miller.
ମୁଁ
ଶ୍ରୀମତୀ ପୁଷ୍ପଲତା ମଶା, ବୟସ so and so, PW1. ପବିତ୍ର କୁମାର, ସ୍ୱାମୀ ପବିତ୍ର କୁମାର ଦାସ,
is the deceased.
ସାକିନ ତିଳଦା, ପୋଷ୍ଟ ଗୋପୀନାଥପୁର, ଥାନା ସାଲେପୁର। ଆଜି ଆପଣଙ୍କୁ ଆମ ଘର ପାଖରେ ଦେଖି ଏହା ଲେଖି ଜଣାଉଅଛି କି ସବୁଦିନ ପରି ଗତକାଲି ରାତି ପ୍ରାୟ 10:30 11ଟା ସମୟରେ ଖାଇ ପିଇ ସାରି ଆମେ ଶୋଇଲୁ। ମୁଁ ଓ ମୋର 2ଟି ଛୁଆ ଘରର ଦକ୍ଷିଣ ପାଖ ବଖରାରେ ଶୋଇଥିଲୁ। ମୋ ଶାଶୁ ଉତ୍ତର ପାଖ ପୂର୍ବ ବଖରାରେ ଶୋଇଥିଲେ। ଶ୍ୱଶୁର 3 ଦିନ ହେବ ଘରେ ନଥିଲେ। ବାହାରକୁ ବନ୍ଧୁଙ୍କ ବିଭାଗରେ ଯୋଗ ଦେବାକୁ ଯାଇଥିଲେ। ମୋର ସ୍ୱାମୀ ଘରର ମୁଖ୍ୟ ଦରଜା ଭିତର ପଟୁ ଚାବି ପକାଇ ଛାତ ଉପରେ ଯାଇ ଶୋଇଲେ। ଆଜି ସକାଳ ପ୍ରାୟ 6 ଘଣ୍ଟିଆ ସମୟରେ ଦୁଆର ଖୋଲିବାକୁ ସ୍ୱାମୀଙ୍କ ପାଖରୁ ଚାବି କାଠି ଆଣିବାକୁ ଛାତ ଉପରୁ ଯାଇ ଦେଖିଲି ମୋ ସ୍ୱାମୀଙ୍କର ବାମ ପାଖ କାନମୁଣ୍ଡା ତଳକୁ ଓ ବେକରେ ଗଭୀର କଟାକ୍ଷତ ହୋଇଅଛି ଓ ସେଥିରୁ ପ୍ରଚୁର ରକ୍ତ ବାହାରି ବିଛଣା ଗାମୁଛା ଓ ଚଟାଣ ଭିଜି ଯାଇଅଛି। ସ୍ୱାମୀଙ୍କ ଦେହରେ ହାତ ମାରି ଦେଖିଲି ସେ ନିଶ୍ଚଳ ହୋଇ ପଡ଼ିଛନ୍ତି। ଗତକାଲି ରାତିରେ କୌଣସି ଲୋକ ଧାରୁଆ ଅସ୍ତ୍ର ଦ୍ୱାରା ମୋ ସ୍ୱାମୀର ବେକ କାଟି ହତ୍ୟା କରିଛନ୍ତି। ମୁଁ ଚିତ୍କାର କରି ମୋ ଶାଶୁଙ୍କୁ କହିଲି ଓ ଗାଁ ଲୋକଙ୍କୁ ଡାକ ପକାଇଲି। ତାପରେ ପୂର୍ବ ପାଖ ଛାତରୁ ତଳକୁ ଡେଇଁ ପଡ଼ିଲି। ତାପରେ ଗାଁ ଲୋକମାନେ ଆସି କବାଟର ତାଲା ଭାଙ୍ଗି ମୋ ଛୁଆ ଓ ଶାଶୁଙ୍କୁ ବାହାର କଲେ। ପୂର୍ବରୁ ଗୋଟିଏ ମୋଟର ଚୋରି ସଂକ୍ରାନ୍ତରେ ଆମ ଗାଁର ପତୁ ଓର ପ୍ରତାପ ପୁରୀ ସେ ତ୍ରିଲୋଚନ ପୁରୀ ସ୍ୱାମୀଙ୍କୁ ହାଣିବ ବୋଲି ଧମକ ଦେଇଥିଲା। ଆମ ଗାଁର କୁନି ଓର
ଗୋଟିଏ ମୋଟର ଚୋରି ଘଟଣାରେ ପତୁ ଆଲିଆସ ପ୍ରତାପପୁରୀ ମାନେ
ଆପେଲାଣ୍ଟ।
ମୋ ସ୍ୱାମୀକୁ ହାଣିବ ବୋଲି ଧମକ ଦେଇଥିଲା। ୟେସ୍।
ଆମ ଗାଁର କୁନି ଓରଫ ସୁମନ୍ତ ରାଉତରା, ପିତା ନଟବର ରାଉତରା ମଧ୍ୟ ପାରିବାରିକ he is nowhere in the picture.
Acha, not in the picture,
not in witness.
Not a witness. Okay, no. Acha.
The defense plea is that
please continue. ଆମ ଗାଁର କୁନି ଓରଫ ସୁଆଂଶ ମଧ୍ୟ
ଆଜ୍ଞା ପାରିବାରିକ କଳନରୁ ମୋ ସ୍ୱାମୀଙ୍କୁ ମର୍ଡର କରିବ ବୋଲି ଧମକ ଦେଇଥିଲା।
ଓକେ।
ତେଣୁ ମୁଁ ସନ୍ଦେହ କରୁଛି ଏମାନଙ୍କ ମଧ୍ୟରୁ କେହି ମୋ ସ୍ୱାମୀଙ୍କୁ ହତ୍ୟା କରିଥାଇ ପାରନ୍ତି।
So either it may be the appellant or it may be the Kunni alias Sumanto Rao.
Agya.
Okay. Agya. Now you come to the evidence of PW1.
Agya.
That
is 31. Page 31.
31.
31. Salary?
Yes. The informant.
I know accused Patu Pratap Kumar Puri, Pavitra Kumar Das is my husband, is the deceased in this case. On 8/6/2003, my husband was sleeping on roof of my house. On 9/6/2003, my mother-in-law told me to bring the key from my husband to open the door, as my husband, after closing the door, had taken the key to the roof. The moment I went to the roof, I saw my husband lying dead with cut injuries. I saw 2 cut injuries on the left side neck of my husband. Seeing the condition of my husband, I cried and shouted. And being senseless, I fell down from the roof of the ground. Subsequently, after Regaining my sense, I reported the matter to police. My uncle-in-law first informed the matter to the police. When police came to my house, I reported the matter to police. I suspect the accused to have committed the murder, as the accused has committed theft of our motor. And when my husband had asked about the commission of the theft to the accused had threatened to kill. I also suspected Kuni, son of Nottavar Raut, as he was looking after our truck, and there was a dispute between Kuni and my husband. Exhibit 1 is the FIR, Exhibit 1 by 1 is my signature. My elder father-in-law has scribed the FIR. Prior to 2 and 3 days of the occurrence, the father of the accused has returned the motor to my uncle-in-law. Cross-examination.
Yeah.
My father-in-law has got 4 sons and 2 daughters. All the sons and daughters of my father-in-law are married. Again says the elder sister-in-law is unmarried and she is named as Basanti. Nanda Kishore, my elder brother-in-law, is serving in the P&T at Bhubaneswar. My father, elder brother-in-law, Ananta, is working at Koraput. Next one is my husband. My younger brother-in-law, Chogola, is a journalist at Puri. Those who are serving in our family resides outside with their family members. Kuni is known as Sumanta Kumar Raut. He is our neighbor. Kuni had got access to our house while he was looking after our truck business. I had got good relation with Sumanta Kumar Raut. Sumanta doesn't take his meal in our house. He does not teach our child. I do not know if Sumanta Raut collects the hire charges of the truck. It is a fact that regarding the collection of hire charges, there was dispute between Sumant Raut and my husband. It is a fact that I had not reported regarding commission of theft of motor by accused and recovery of the same. I have not shown any document to police to know that we had a motor. My husband was a contractor. It is not a fact that my husband doesn't do any work. It is not a fact that my husband has incurred loans from the villagers to manage my family. It is not a fact that my husband has got enmity with many villagers. It is not a fact that there was no commission of theft of motor by the accused and accused father had never returned the motor. Prior to 2 or 3 days of the occurrence, it is not a fact that neither I had reported nor stated before police that prior to 2 to 3 days of the occurrence, the father of the accused returned the motor to my uncle-in-law. Brahmarbal Das is my uncle-in-law. Had been to the PS to report the matter prior to my report. It is not a fact that the accused has been falsely implicated in the case.
ଏଗୁଡାକ କୋଉଠି କହିଲା ଯେ ଏ ଯୋଉ it is not a fact that neither I have nor I have stated that prior to 2 to 3 days of the occurrence, the father of the accused returned the motor through my
uncle-in-law.
ଏଗୁଡା ତ chief examination କିଛି କହିନି
ନା
ଏଗୁଡା କାଇଁ ପଚରା ହଉଥିଲା? It is not a fact that I have it is not a fact that neither I have stated before police. ସେ ତ ମୂଳ chief ରେ ହିଁ କହିନି, ସେ police ପାଖରେ କହିନି ବୋଲି ଆଉ ସେ ପଚରା ହଉଥିଲା କାହିଁ? ଯଦି କହିଥାନ୍ତା chief ରେ ହଁ ନ କହିଥିଲେ police ପାଖରେ 161 ରେ confront କରାଇଥାନ୍ତା. All right, continue.
The last part, this is important. The staircase is inside our house. The main gate was closed, and ordinarily it is not expected that somebody will come to our house through the main gate when it is closed. The main gate was closed in the night of occurrence. This is, my lord, PW1.
Okay, what about PW2?
PW2 is uncle-in-law. Even though she says that he is the scribe, but scribe is somebody else. I know the accused present in the dock. The deceased is my nephew. I am ward member of my village. The house of the deceased is adjacent to my house. On 9/6/23, we heard shouting and crying of PW1, and when we went there, she told that somebody has killed her husband, and saying so, she jumped from the roof and became senseless. After regaining her sense, she told regarding the death of her husband. As the main gate was locked, some person broke the door and entered. Then we all saw the dead body of the deceased on the roof. Subsequently, I reported to the police over telephone. When PW1 told me that the accused has threatened to kill the deceased, centering to commission of theft of one motor, we also suspected the accused. Prior to 2 months of the occurrence, there was commission of theft of motor of the deceased, and for that reason, there was exchange of words between accused and the deceased. When it was decided that the matter will be reported to police, the father of the accused told to search the motor, and accordingly he returned the motor through me, and I handed over the motor to the deceased. The deceased is my nephew. Cross-exam. The distance between the house of mine and the deceased would be 30 feet. There is an open space in between my house and house of the deceased. There are open spaces all around the house of the deceased. The population of our village is 240 and 44 families lives in the village. I have got good relations with the family members of the deceased. Pavitra had one truck. Kuni and other boys of her village and the boys of Salepur were helping
my husband.
husband. In dealing with the truck. I cannot say if Kuni takes care of the truck. Kuni was in good terms with the family member of the deceased. He had also got visiting term to the house of the deceased. The business did not run smoothly. Thus, the deceased has incurred loan from many persons. I cannot say a specific date when the motor of the deceased was stolen. No report has been given to police station regarding commission of the theft of the motor. No panchayat has ever been convened in connection with the theft of motor of the deceased. I cannot say the make of the motor. I cannot say when the motor was purchased. Chitrotpala river passed by side of my village. Our villagers depend upon that river. It is not a fact that the deceased has no motor at all. It is not a fact that there was no commission of theft of motor. I had not had the accused and the deceased exchanging words in connection with the theft of motor. It is not a fact that I was deposing falsehood. She was again recalled, my lord, and re-examined. On 9/6/2003, while police came, we also present with him. The police seized blood stain and some hairs stuck to the right palm of the deceased and prepare the seizure list, exhibit 2 in the seizure list, and 2/1 is my signature. About 100 to 200 people enter into the house of the deceased after hearing of the occurrence and before arrival of police. Besides our villagers, the people of other villagers came to the spot. Bailo, Keutuli, Morada, Sarada villagers are adjacent to our village. Some of the persons of the above named villages had also come to the spot before arrival of the police. All the above persons were present at the arrival of the police. No attempt was made to report into writing immediately after the occurrence of the police station. After I heard the fact from PW1 that it is a fact that I have not stated before the police that I had informed the matter over telephone. It is a fact that I have not stated to police that PW1 told me that she was suspecting accused as previously there was a quarrel between the accused and the deceased, centering to commission of the theft. Besides seizure of the blood stain and hair, police told me to keep the wearing apparels of the deceased and told me to produce the same in a bundle in the police station. I do not know as to who others signed the seizure list. I do not know as to who had signed the seizure list prior to my signing. I am a matriculate. I know how to read and write. I signed the seizure list in my house. It is not a fact that there was no seizure of any article in my presence. It is not a fact that there was no commission of theft of motor by the accused. It is not a fact that I have got no good relation with the father of the accused. It is not a fact that PW1 is my daughter-in-law. I am deposing falsehood at her instigation. Again, my lord, he was recalled. It is a fact that
হেয়ার কথা কি কইলা
এই কইলে page 36 para 4 on 9/6/2003 while police came we are also present with him. Police seized blood stains and some hairs stuck to right palm of the deceased and prepare seizure list 2. It was confronted. It is a fact that I have not stated before police that the hairs were found in the right hand palm of the deceased. Page 38 re. He was again confronted with his statements.
এটা admit করছে I have not stated before the police that hair were আচ্ছা What is that particular seizure list? Exhibit
2.
8A2 था देखिए. Yes, Pabrika.
Then comes my lord UW3, that is father of the deceased. He says about enmity. He says about the enmity, prior enmity.
That motor and
Again,
threatening.
again. The deceased is my son. It is at page 39.
Yes.
The deceased is my son. I know the accused present in the dock. On the date of occurrence, I was at Kalyanpur. After hearing about the occurrence, I came and saw the dead body of my son. Prior to 1 month of the occurrence, there was commission of theft of our motor, as the accused has a quality of committing theft. I went to house of the accused and asked the accused if he has committed theft of motor, and for which he abused me in filthy language. By the time the deceased reached there and protested the action of the accused, and then the deceased told to report the matter to PS. But the father of the accused told us not to report, saying that he would search the motor in the night following occurrence of confrontation, centering to the commission of the theft of motor. The father of the accused told the ward member either to return the motor or to pay 2,000 towards cost of the motor. Then on the next day, the brother and father of the accused returned the motor through the ward member. Due to above reason, the accused had threatened to kill the deceased, as we suspect the accused. Cross-examination. Sarveshwar Behra is my grandson-in-law, and on the date of occurrence, I was in his house. The village of my grandson-in-law will be at a distance of 40 kilometers from my village. On the way, we have not come across with any PS. On the day when I reached the village, I was examined by the police. While I reached in my village, I saw police people and other people gathered in my house. I heard about the occurrence from the villagers. It is a fact that I have not stated before police that as the accused was in habit of committing theft, I straight went to house of the accused and asked if he has committed the theft of motor. And by that time, the accused abused me in filthy languages when my son reached and told him to report the matter at police station. It is a fact that I have not stated before police that the father of the accused told me not to report the matter at the police station and he would search the motor. It is a fact that I have not stated before police that in the night of our confrontation, in connection with theft of motor, the father of the accused told to ward member that either he would return the motor or pay rupees 2,000 towards cost of the motor. It is a fact that I have not stated before police that the father and brother of the accused returned the motor through the ward member. I have got documents to show the possession of the motor. We have not given the papers of the motor to police. I cannot say the make of the motor. My son had purchased the motor. I cannot say the details of the purchase of the motor. It is not a fact that we had not possessed any motor at any time. It is not a fact that there was no commission of theft of motor. It is not a fact that I am deposing falsehood. Next is formula.
Yes.
Who is brother of the deceased? I know the accused Patu Pratap Puri. My brother Pavitra Kumar Das is the deceased in this case. After receiving the phone message regarding death of my brother, I came to my village and heard that the accused has killed my brother. I was present at the time of inquest. Exhibit 3 is the inquest report and Exhibit 3.1 is my signature with my endorsement. Cross-examination, I have got no knowledge about the occurrence. I was residing outside my family members at the time of occurrence. At time, I was helping the uncle and aunt of the accused. I had provided a truck to the deceased during my service career. The deceased was looking after the said truck. He was taking help of Kunni, Sumantukumar Raut of our village. I cannot say who was releasing hair charges of the truck. I cannot say if there was quarrel between Susanto and the deceased regarding the collection of hair charges of the truck. One Kuni and Sumanto was arrested by police in connection with this murder, but subsequently he was released. I know Mangulu Mishra works in the fire brigade department. His brother-in-law of Sudhanshu Shekhar Mishra is a DSP. I cannot say if Susanto is related to Sudhanshu. After 10 days of occurrence, the accused was caught hold at Potamundai. When I reached in my house, I saw many people near our house. It is not a fact that my brother and the deceased has incurred loan. It is not a fact that the deceased has got enmity with many people. It is a fact that I have not stated before police that the accused was caught hold at Potamundi.
This PW5 is the scribe of the affair.
Millard. He says, but affair says something else. But anyway, he is the scribe of the affair, PW5. I know the accused and deceased in this case. After hearing the death news of Pavitra Kumar Das, I had been to his house. There, on the request of PW1, the wife of the deceased, I scribed the affair as per her version.
Leave it.
After-
That is the scribe of the affair. Leave it. That
Again,
6 has not supported the
it's
process.
hostel.
Okay.
It is a blacksmith who was examined, but the learned trial court has disbelieved him. He has not relied on his evidence.
Okay. Now you
If your
come
lordship
to
will ask, I will.
7 ki kaun?
7, my lord. Hostile.
No, 7 ke hostel.
No, 8 hostile. Sorry.
7 is the blacksmith.
7 is a blacksmith. His evidence was not relied upon. Who says that?
He had handed over. He prepared and handed over one sword to the appellant, right?
Yeah.
That is his evidence.
Only because the name of the village was
Different.
that's why the trial court has not relied upon it. But that also this witness has stated in his chief.
No, it's all right. See, you see, let us say one sword was given. He has handed over that sword to the accused, and unless it is further proved that that sword was the weapon of offense, that recovery becomes immaterial, and for that I have known no document to show that I have every person to prepare a sword is an offense. I have prepared, but I have no declaration.
No, the faint blood was there on the sword, but that could not be identified. The origin could not be identified. However, the sword was produced before the post-mortem doctor for medical opinion. And he has opined that this sword, the injuries that the deceased has sustained, could be possible by means of this MO1.
But he denies to have any sign of blood on the sword.
Okay, who had PW8 has
In
stated?
fact,
I heard about the recovery of the sword.
Miller, that
I
is
was not present at the time, all right.
that is PW8. PW9 is the recovery witness. But man of, in fact, the date was throughout in the evidence of PW14 is 9/6.
9/6 is the documentary evidence. That exhibit is kete number sec eta sword ro?
এটা
What is the
কিন্তু
exhibit?
ଟିକେ ଭେରିଫାଇ କଲେ ଜଣା ପଡୁଛି ଏଠି ଡେଟ୍ ଗୁଡା ଭୁଲ ଲେଖା ହେଇଛି।
No. Exhibit. What is the when the sword was recovered? What is the exhibit list? Please tell me.
That is exhibit 4.
4.
Again.
Exhibit 4 is dated 9/6. No, this 22/6/2003. So ठीक କହିଛି ତା ଆୟକୁ ଗୋଟେ ଲୁହାରେ ତିଆରି ଖଣ୍ଡା ଯାହାର ଆଗପଟ ମୁନିଆ ଥାଇ ଧରିବା ପାଇଁ କାଠର ହ୍ୟାଣ୍ଡେଲ ଲାଗିଥାଏ ଧରିବା ପଟ ଚଉଡା ଆଗପଟକୁ ଅଳ୍ପ ବଙ୍କା ଥାଇ ମୁନିଆ ହୋଇଛି କାଠ ହ୍ୟାଣ୍ଡେଲ ଲମ୍ବ 12 cm ଗୋଲେଇ 1.5 ସେଥିରେ ରକ୍ତ ଲାଗିଥିବାର ଅନୁମାନ କରାଯାଏ ଏଟା ହେଉଛି 9/6/8/9 ଘଟଣା 22 ନାଇଁ FIR ହେଇଛି ସରି
8/6/2003 date of incidence is 8/6/2003
ଆପଣ 8/3 କଣ କହୁଛନ୍ତି ଗୋଟା
as per the FIR
ଆପଣ ଗୋଟେ କୋଉ ଜାଗାରେ ଲେଖିଛନ୍ତି କି ଆପଣ 8/3 ବୋଲି ଏଟା ଭୁଲ ଲେଖିଛନ୍ତି ଆପଣ ଦେଖିଛନ୍ତି intervening night of 8/3/9/3 ଘଟଣା ହେଲା ବୋଲି let us see come to the FIR.
ସେଇଟା ଭୁଲ ଲେଖିଦେଇଛି ମୁଁ।
No, it's a wrong.
I'm sorry, my lord. That
Eight-
has misled me. I'm sorry, it is 9/6.
8696 intervening night ରେ ଘଟଣା
ଆଜ୍ଞା,
ହେଇଛି. And recovery
It's 12 days
was
after.
made on 22/6, not 3 months after.
12 days after. PW9 is the recovery witness and witness to the statement given by the appellant.
What was found from that sword, which is the page, C report is at page
Page 84.
Man, it is 81 na
84 recovered by state foreign.
That is marked as I at page 81, and it is blood, faint, no opinion, inconclusive, right?
Page 84 also.
The same ଜିନିଷ ସେ
ଆଜ୍ଞା।
81 ଟା ବି ସେୟା ଲେଖା
ଆଜ୍ଞା।
ହେଇଛି। ବାକି ସେ ହେୟାର ଟା ଉପରେ କଣ ଡିସିସନ ଆଣିଛନ୍ତି? ମୋଦି ଜୁରିସ୍ପ୍ରୁଡେନ୍ସ ଦେଖିଛନ୍ତି ହେୟାର ଉପରେ?
Here tab run because my lord, the report itself shows that it is inconclusive and was not sufficient for any opinion.
No, that is only regarding blood, your lordship.
Tally କଲା ପରେ କଣ
It
କହୁଛନ୍ତି?
has been tallied.
Mishra said that it tallied ବୋଲି।
Item 7 ଟିକେ ଦେଖୁন, page 81.
Item
7 million.
two strands of hair.
No opinion because quantity is insufficient.
That is regarding the blood found on the hair, your lordship. Not on the hair itself.
hair ଟା କୋଉଠି ଅଛି?
Hair ଟା next page ରେ ଅଛି. The hair marked by exhibit D tallied with the hair marked as exhibit N.
The hair marked by exhibit D.
ଆଜ୍ଞା।
D ଟା କୋଉଟା? ଏଇଟା D.
ଏଟା 17 ଟା। 17
tallied with the hair marked as exhibit N.
ଆଜ୍ଞା।
N ଟା କୋଉଟା?
N is 17, your lordship.
17 sample hair of accused.
But did not tally with the hair by exhibit M. M konda?
M is the pubic hair of the accused.
Pubic hair. तो 7 टा लिखिଛନ୍ତି
My lords.
ଏଆର ଏଇଟାର ଅରିଜିନ ମଧ୍ୟ ସେ ଦେଇନି, नो ଓପିନିଅନ ଦେଲା, ମାନେ ଏଟା ହ୍ୟୁମାନ ହେୟାର କି କଣ, ପେଜ 81 କୁ ଆସନ୍ତୁ।
My lords. 81, yes.
ହଁ, ସେ ଯୋଉ ବାଳରେ ସିଏ ଷ୍ଟେନ୍ ରକ୍ତ ଲାଗିଛି, moderately smear ଲେଖା ହେଇଛି।
Lordship.
So far as origin is concerned, it is silent.
That my humble submission is that origin is relating to the origin of the blood found on the
No,
hair,
no.
your lordship.
Okay, and the
Description of exhibit.
examination and biological stains and hairs जो रही chapter टा, how the hair is to be examined. When a hair on examination is found to be human, its comparison with the controls obtained from the concern is required to be carried out.
But it has completely tallied with the hair of the accused, your lordship, the sample hair of the accused.
It can't be, you cannot give such a opinion, you see. Cannot from that you can say that this is the hair of that. You can say just the negative, that this is not the hair of so and so. এই version ही तमें दिया हो. The question of hair is relevant to American government. Microsoft found to be limited. What the Modi has stated,
Lordship.
that microscopic hair comparison has been demonstrated to be a valid and reliable scientific methodology, but at the same time, microscopic hair comparison alone cannot lead to personal identification, and it is crucial that this limitation be conveyed both in the written report and in the testimony. The science of comparison of hair has not yet reached perfection, like the science of comparison of fingerprints, where the scientific officer posted in the forensic science laboratory had not carried out all the tests meticulously, did not measure the diameter of the shafts of the hair or its length, taking impression of the cuticles of the hair, note the shapes, appearance, colors of the hair, or the direction pointing out of the hair, it would be unsafe to relying upon so and so. These are the reasons that is to be given. এটা ଟିକେ এই କୁଆଡେ ଗଲା ସେ ଏଟା এটা মনোপত্র করা ম্যাডাম।
That report has to be examined then, Your Lordship, because this page 82, which is
Yeah.
the final observation regarding the tallying of the hairs, that has
No,
been done.
what it says that if you mention in the report like that, that would not be acceptable unless you assign the reasons how you came to the conclusion.
Here it is morphologically and the microscopic features are similar, Your Lordship, with N and dissimilar with M.
You see how many tests have been prescribed, that you are to first measure the diameter of the shafts of the hair or their length, take impression of the cuticles of the hair, note the shapes, appearance, colors of the hair, or the directions of the pointing out of the hairs. It would ଆଜିକାଲି କଲର ମାରି ଦଉଛନ୍ତି, ତ କେମିତି କରିବ ତାକୁ? ଯଦି ଏଇ ତ ବୋଧେ ଦିଟା ଯାକର ଆଗେ ସେ ଯୋଉ ଡାଏ ଗୁଡାକ ବାହାର କରିବ, ହେଲା, ଯଦି ଅରିଜିନାଲ ଥିବ ତ ଅଲଗା, ଯଦି ଡାଏ ଥିବ ଦେନ୍ ବାହାର, ତାପରେ ତାର କେମିତି ମୋଡା ହେଇଛି, ତାର ମାନେ ପଏଣ୍ଟ ଆଉଟ କୁଆଡେ କରୁଛି, ତ ବିଭିନ୍ନ ଏସବୁ ଜିନିଷ ହେଇକିନି କମ୍ପେୟାର କରିକିନି ଦେନ୍ you can give report, but again it says that it is not has not reached perfection. The science of comparison of hair has not yet reached perfection like the science of comparison of fingerprints. So এটা yeah. The decisions are also there. Division bench of the Calcutta High Court, 86 Criminal Law Journal 622. 86 Criminal Law Journal, typically Magachu 622. Imag Su, HIMAGSHU Pahari, PAHARI versus the state. So the London trial court accepted the report of the senior scientific officer on scrutiny of his evidence. We consider we consider it unsafe to act upon the report. It has been elicited in the cross-examination. Their scientific officer was examined also. He did not measure the diameter of the shafts of the hair or their length, did not take the impression of the cuticles of the hair, did not note the shapes, appearance, and the colors of the hair or the direction. Modi jurisprudence in there. Pointing to the hairs, the science of comparison of hairs has not yet reached perfection like science of fingerprints, where therefore all the tests were not meticulously carried out. It would be unsafe to rely upon the report. We therefore leave out of our consideration the report of the scientific officer. Then again, it's a division-based decision of that court. So it is now turning to the opinion expressed by the CFSL regarding matching of the alleged sample hair with that of the hairs recovered from the right hand fist of the deceased. He said the report does not conclusively prove those hairs were of so-and-so. The hair exhibits so-and-so found to be human in origin. Hair of so-and-so, then again same thing. The report of so-and-so in our mind is not conclusive. According to this report, if I can say that hair analysis has not yet reached perfection. So what a decision court the Kerala High Court, that is 89 Lekho, 1989 3. Crimes 238. In that case, the court observed that the hair analysis has not yet developed into a perfect science. This fact was accepted by all major authors of medical jurisprudence. Similar view was in the case of Neeraj versus State Monopatro Swanso, where in similar circumstances, CFSL report that hair was similar, the court observed there is distinction between similarity and identity. There can be similarity, but identity can still be different. In the present case, the result of analysis is that the sample hair and the hair recovered from the hand of the deceased were similar. Experts have not opined the identity of the hair was of the same or that the origin was from the same source. Identity of the hair being not established, it cannot be said that the sample hair or the hair recovered from the muthi of the deceased were of the same persons. Similarly, of hair does not conclusively prove the hair come from the same origin and of the same person. Then another decision has been quoted, that is 1984 bracket 2 crimes 815. Sampling and analysis of hair samples suffer from many limitations. Most notably, standard procedures have not been published for collecting, washing, analyzing hair samples. Many questions regarding appropriate sampling analytical procedure remain unanswered. CFSL report does not elaborate how the expert came to the conclusion that there was similarity between the questioned hair strands and the sample hair of the deceased. Sample hair of the accused. The characteristics like scale count, number of scales per cm, shaft diameter, its variation from the root to the top, medullary index, that is the ratio of the medulla diameter and the shaft diameter, pigment and shape of the cross section have not been dealt in the report. It is not certain if the hair strands examined by the expert was full hair with the root and the tip was intact or were representative of the body part or parts concerned. It is uncertain if adequate number of hair were obtained as questioned here. Then they have quoted the medical jurisprudence of Modi. ସେଇଟାକୁ ଯୋଉଟା ଆମେ ପଢୁଥିଲୁ ସେଇଟାକୁ ଇଏ କରିଥିଲେ. This decision relates to ଯୋଉଟା decision ଆମେ ପଢୁଛୁ ଏଟା ହଉଛି this is a decision it is Alok Singh Patina hala Alok Singh versus State. Justice Sanjeev Khanna and Justice S.P. Garg, and it was decided on 12/7/2022. It's a Delhi High Court decision, and that is reported in Manu MANU/BE/3150/2012. Okay. कोई खबर दे देलनि तो जिसोड़ा 3-4टा डिसीजन 3टा डिसीजन भावছে ତାହେଲା এটা ଦେଖନ୍ତୁ এটা another decision. It's a Vijay Kumar versus those decision reference to those. They have quoted that all those decisions State of Kerala versus Baby Joseph. Then report found the report of the expert on another in conjunction with in Calcutta High Court Himanshu Prahari versus court, and so that is 86 criminal law जना जोटा कि 622 जोटा हम दिया. Then Ashok Kumar versus State दिया लगी. Ashok Kumar टा होची state of MP later. ILR 1997 MP बुझलो 551.
Ashok Kumar versus State of Madhya Pradesh.
Ashok Kumar versus State of MP मैंने मध्य प्रदेश हला
Decided on 4999.
ILR 1997 MP मैंने मध्य प्रदेश 551 होची page इथिबो voice right here, and it is held like this, that hair seized from the fist of the deceased and hair regeneration development hair to the singular slants never division bench testimonial na that the अन्य थिला सहित पहना. Again that is quoted State of Kerala versus Ranjan. The hair collected from अच्छा but this one like a state of Kerala. State of Kerala hala versus Ranjan. এটা হচ্ছে অনুপাত্র তো ଅଛି but ଆଉ କିଛି ନାହିଁ ଅଛି এটা ମନୁ ଲେଖିବା. ମନୁ KE 07002003. The science of hair identification is fast advancing science, and even it is assumed that so-and-so is not possible or can be so-and-so with other circumstances. ये टिके आउट टिके अलगा कहले कहले other circumstance जदि थिबो ताहले एटा additional circumstance नि आई पारिबो. एडिशन ने कहले जे on consideration on consideration of all these decisions, it appears to us that even though the science of hair identification may be quite an advanced science, and it may be possible to determine the source, it would not be safe to solely relying upon the similarity of the hair to convict an accused person. There must be some other connecting evidence to link the accused with the crime. Although the analysis of the hair would be an important piece of evidence. For this reason, we cannot definitely say that the 4 strands of hair in the right fist of the deceased, which are apparently similar to the hair of the appellant, are the hair of the appellant. Even the expert could not say that, but what is the position if we take the relevant into consideration? You know, this decision is এটা হচ্ছে edition এটা ই পর্যন্ত এটা ডেলি রা. আচ্ছা, this decision is Vijay Kumar, note down, Vijay Kumar versus State. Justice Madan B. Lokur and Aruna Suresh. And it is again Manupatra, MANUDE 9836/2006.
Vijay Kumar. Another Supreme Court decision, 66 Supreme Court. Page is 8 to 1. Party Nahala AANBI Kanbi Karshan Jadhav versus State of Gujarat. It is argued that the finding of the hair was of no consequence and at least chemical examiner was not proper expert who could depose as to the similarity or otherwise of the hair. The writers of the medical jurisprudence, however, stated that from the microscopic examination of the hair, it is possible to say whether they are of the same or different colors and sizes. And from the examination, it may help in deciding where the hair come from. In Taylor's medical jurisprudence, some cases have been given showing that the hairs were identified so and so of a particular person. Supreme Court, upon evidence furnished by the prosecution based on the presence of the hair, it would get a good question. This the division bench of the courts for answering. Rayson alias Paul, Patinahala, Royson alias Paul versus State of Kerala, 90 bracketed 2 criminal Kerala law journal. In this case, the court considered Ravi Achan's case supra, cited in support of the contention that the evidence based upon comparison of the hair cannot be acted upon. The division bench observed that though the science is having certain imperfection, at least in certain aspect, the science could be considered to have attended at least nearness to the perfection. The court said in the textbook of criminal investigation by Sachan's fifth edition, it is said that detailed structure of medulla and its diameter compared with that of the hair shaft as a whole, together with the distribution and character of pigment, the scale pattern of the cuticle, the appearance of the hair in transverse section, all provide features which in the aggregate enable the expert to identify any given hair with certainty. From the microscopic examination itself, it may be possible to say whether the hairs are of same and of different colors of size, and from the examination, it may help in deciding where the uh, hair came come from. In Ravi Archan case, the question which came up before this court was whether the hair analysis could be the sole basis of conviction. In the instant case, there are other items of the evidence. One says sole basis e mana kale. So, but other evidence kale it out additional feature which I will usually say this distance says. It out a decision which Allahabad High Court division bench decision. Patinahala Komal KOMAL versus State of UP. Division bench whether it is reported in Manupatra 39. Manupatra Palalala MANUUP 13962005. So what has been held here like this? The last incriminating circumstance is similarity of hair between the hair recovered from the fingers of the deceased and hair of the appellant. In this circumstance also, link evidence is missing. The hairs were seized from the fingers of the deceased on 25 to 2003 and the hair of the appellant were taken into possession on 26 to 2003 and they were dispersed for the analysis on 2/4/2003. The analysis report is also not conclusive in nature. The report shows that hair in both the packets were found of human origin. Human origin madhya kohutla. Some of the hair of packet number 2 were similar to hair of packet number 1. Then in case of Swan Soji, jo Calcutta High Court decision ta rely kale, the science of comparison of hair has not yet reached perfection like science of comparison of fingerprints. जोटा कि मोदीଙ୍କର jurisprudence ରହୁଛି.
it is also necessary to point out it is not clear whether the hair of the seizure was properly costed. Acha, ei jo hair ta apankara ଆଉ ଗୋଟେ ଜିନିଷ ଯୋଉଟା ରହୁଛି ଏ ହେୟାର ଟା ଯୋଉ ଆପଣଙ୍କର ରିକଭରି ହେଲା ତା ଯୋଉ ଫିସ୍ ଟୁ, କାରଣ ଏଇଟା ଆପଣଙ୍କର what is the date of seizure of the hair?
Seizure of the hair will at same day.
ନାଇଁ ଏଇ ଯୋଉ ସାଇଣ୍ଟିଫିକ ଅଫିସର ସେ ହଉଛନ୍ତି ନେକ୍ସଟ ଡେ ସାଇଣ୍ଟିଫିକ ଅଫିସରଙ୍କର ସେଟା ବନ୍ଦ କର। ହଁ ଏଇଟା ହଉଛି that was seized as per the seizure list ହଉଛି exhibit 2
ଆଜ୍ଞା
ହେଲା। exhibit 2 ରେ ଏଟା ବ୍ୟାକ୍ କର। exhibit 2 houchi the hair pieces collected from the belly and right palm of the deceased, right?
Yeah.
And that date is seizure date is 9/6/2003, right?
ଆଜ୍ଞା
9/6/2003 1:30 PM ହେଲା।
ଆଜ୍ଞା
ଏଇଟା ଯୋଉ ଆଇଓ ଯୋଉ ଏଭିଡେନ୍ସ ଟା ଦେଲା ଏଟା କୋଉ ପାରାଗ୍ରାଫ ରେ ଦେଇଛି?
ଏଇଟା ଦେଇଛନ୍ତି
ମାନେ ସାଇଣ୍ଟିଫିକ ଅଫିସର ଏକ୍ସାମିନ ହେଇଛନ୍ତି?
ନା ହେଇନାହାନ୍ତି।
No.
ଆଚ୍ଛା ସାଇଣ୍ଟିଫିକ ଅଫିସର ନାଇଁ ସାଇଣ୍ଟିଫିକ ଅଫିସର କଥା ଫାଷ୍ଟ ଦେଖିବା। ସାଇଣ୍ଟିଫିକ ଅଫିସର ହୁ କଲେକ୍ଟେଡ, କାରଣ ଏଟା ସାଇଣ୍ଟିଫିକ ଅଫିସର କୁ କଲେକ୍ଟ କରିଥିଲା, ସିଏ ମାନେ ଏକ୍ସାମିନ ହେଇନାହାନ୍ତି।
ନା
Now,
ହେଇନାହାନ୍ତି।
let us see the evidence of the IO. IO, you said that it is PW 14,
14
right?
ଆଜ୍ଞା
Sure. 67.
67 is the IO. Shall I read it?
Yes, yes. Paste সেটা খালি এইটাও খালি উঠে এইটা উঠে কি বোটাম সেপট করবে তা উপরে করবে এটা বাহার করবে বইটা এটা। So it is PW 14
14
the IO କୋଉ ଲାଇନରେ କହିଛି ସେ ଯୋଉ ଶେୟାର କଥା?
page paragraph 4
paragraph 4 let us also. Thereafter the SO collected the sample blood of the deceased by means of gauze cloth handed over the same to me. Besides, he also handed over blood stain collected from the staircase,
railing of the stair.
railing of the staircase. He also handed over the hair pieces. 8 was important.
Again.
He also handed over the hair pieces collected from the belly and hand of the deceased. He also collected hair stalk to the right palm of the deceased. I also seized all these articles. So this is the seizure list. So where is the evidence that it was kept in sealed cover? It was sealed at least. After the scientific officer to recovery kare na.
ଆଜ୍ଞା
Eta 9 ତାରିଖ ଦିନ ହେଲା।
ପାରା 6 ରେ ଅଛି।
ହଁ
ପାରା 6
ପାରା 6 ଦେଖିବା। ହଁ on 10/6/1 so I seized the wearing apparels of the deceased.
ଆଜ୍ଞା
Beside this said seizure
seizure sample hair
Swanso seized 2 packets of Swanso sample and blood stain at 8 mm. এটা হচ্ছে সেই যে
deceased ର
deceased ର ଆମେ ଏଇ ଯୋଉ ହେୟାର ଟାକୁ ଯୋଉ କଲେକ୍ଟ କଲା ତା ହାତରୁ ଯୋଉ ତା ପାମ୍ ରେ ଯୋଉ ଥିଲା ସେଇଟାକୁ ଇଏ କଲା ପରେ ଏଇ ଯୋଉଟା ଆପଣ ପାରାଗ୍ରାଫ 6 ରେ ଦେଖେଇଲେ
ଆଜ୍ଞା ଆଜ୍ଞା
ସେଇଟା ଯୋଉ ମେଡିକାଲ ଅଫିସର ଯୋଉଟା କଲେକ୍ଟ କରିଥିଲା ଆଫ୍ଟର ଦି ପୋଷ୍ଟମର୍ଟମ ଏକ୍ସାମିନେସନ ସେଇଗୁଡାକ ପ୍ରଡ୍ୟୁସ ହେଲା
ଆଜ୍ଞା
ରାଇଟ।
ଆଜ୍ଞା
So Mr. Mishra,
Lordship.
concealed in presence of the witnesses also forwarding forwarding reference is ये kind हाँ evidence ना तो लिख दो से तो मैं सब आए मैंने ये printed हाँ देता है तेणु एठी IO is that person who was given those years. So where is
Yes,
the
no,
evidence that it was kept in sealed cover? କାରଣ ଏଇଟା ଗୋଟେ ସିଲ୍ଡ କଭରରେ ରଖିବା କଥା ଆରୁଟାକୁ ମଧ୍ୟ ଯୋଉଟା 10 ତାରିଖରେ ଆଚ୍ଛା ହଁ ସେଇଟା ନୁହେଁ ଏବେ ଆମର
23 ରେ ଯୋଉଟା କଲେକ୍ଟ
In the forwarding report, Your Lordship may see all the articles have been sent in a different seal cover, Your Lordship.
no that is not clear ଆପଣଙ୍କର accused କେବେ arrest ହେଲା
22/6/2003.
accused hair collection ହେଇଛି ବୋଲି କାଇଁ evidence
23/6 23
କି evidence କାଇଁ କିଏ
para 10
acha I sent the accused to SC Medical College for examination. I seized one sample packet of nail clipping in one sealed packet of pubic hair and another sealed packet containing the hair collected by the MO and handed over to this escorting constable. Acha. So ଏଇଟା ହେଲା appellant ରେ ଏଠି collect ହେଲା ଏବଂ sealed packet ମିଳିଲା ତାକୁ but ଏଠି ଯାହା ଜଣା ପଡୁଛି ଏଇଟା ତାକୁ ଦିଟା ହେୟାର ଆସୁଛି ଗୋଟେ ହେୟାର ମିଳିଲା ତା ଯୋଉ ଡିସିଜ ର ହାତରୁ ଆଉ ଗୋଟେ ମିଳିଲା ଏଠୁ ଯୋଉ ଡିସିଜ ଯୋଉ ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟ ହବା ପାଇଁ so ତିନିଟା ହେୟାର ପାଇଲା ତେଣୁ ଆକୁ କଣ ସେ ମାର୍କ କଲା ଦେଖିବା ଆପଣଙ୍କର ରିପୋର୍ଟ ରେ ଖାଲି ଗୋଟିଏ ଏଭିଡେନ୍ସ ଆସୁଛି ଯେ ଇଟ୍ ୱାଜ ସିଲ୍ଡ ଦ୍ୟାଟ୍ ଇଜ ଦ୍ୟାଟ୍ ଯୋଉଟା accused to collect ହେଲା
Report is only of the hair strands, those were found on the right palm of the accuser, those 2 strands of hair. The chemical examination report, the strands of hair, those were found on the right hand of the accused. Those have been sent for chemical examination.
let us see
My lords.
ଖାଲି ଖାଲି ତାକୁ ପଠେଇଲେ କଣ ହବ ଆପଣଙ୍କୁ କମ୍ପାରିଜନ କରିବାକୁ accused ବି ପଠେଇବାକୁ ପଡିବ ନା
Yes, accused also the sample hair.
ଆପଣ ଗୋଟେ ପଠାଇଛି ବୋଲି ଆପଣ ତିନିଟା କଲେକ୍ସନ ଆସିଛି ବର୍ତ୍ତମାନ ଦେଖନ୍ତୁ one sealed packet so and so
page 77 lordship may take item number 7 your lordship
प्रथम होची 77
item number 7 one sealed packet containing the hair pieces collected from the belly and right palm of the deceased by
जोटा कि एटा paragraph number 4 रे मेंशन हेची of the IOS evidence this was collected by the scientific officer right एटा मार्क हेची exhibit D अच्छा तापरे आउ कोठा अछि हेयर रो देखंतु आउ गोटे देखंतु एज टा देखंतु जोटा 11 नंबर one sealed packet containing scalp hair of the deceased जो विषय रे कुआ गला paragraph number 6 रे सेटा होची एच हैला तापरे आउ गोटे accused to जोटा
16 your lordship page number 79 item number 16 17 your lordship
17
my lord 17 one sealed packet containing hair of the accused Pratap Puri
right सेटा होची मार्क एन वर्तमान तांकू क्वेरी वर्तमान कोन करागला देखंतु नेचर ऑफ एग्जामिनेशन रिक्वायर्ड
question number 6 your lordship D and whether the exhibit D tallies with exhibits M
whether
and
the
N.
exhibit D माने होची जोटा ता हातुर मिलला
lordship
D tallies with exhibit M exhibit
M and N
M कोटा म
M is the pubic hair of the accused your lordship.
अच्छा
and N is the sample hair.
Then why you have not asked that whether it tallies with H or not? निजो बाଳ ହେଇଥାଇ ପାରେ exhibit M is public hair ସେଟା pubic hair ସେଟା ଅଲଗା କଥା now this what is the now let us see that D टा कोन कला D टा आसिला 2 strands of hair and that is marked as D blood was found extends moderately smeared, no opinion has been given about the origin. Quantity insufficient. Well, it relates to that perhaps blood and
Yes.
origin madhya kichi dei parlani. Now the next one is H. H is some not stained with blood, no opinion given. Then N. N টা হচ্ছে sample hair of the accused, ହେଲା ଯୋଉଟା କି mark ହେଇଥିଲା N. ତା ଦେହରେ କହିଛି not stained with blood.
No opinion.
ତା ଭିତରେ no opinion, କିଛି opinion ଭିତରେ ଖାଲି. The hair tallied, hair marked as exhibit D, ମାନେ ସେ just to stand tallied with the hair marked as N, but did not tally with hair marked as M. M টা মানে সে pubic hair.
Gotcha.
So no question has been put about comparison of D with H. So if this is the nature of evidence, the first one, let us say that no eyewitness, number one. And the first circumstance about that theft of motor. Theft of motor, no FIR.
No, sir.
Asha, no document that to show that he was having a motor. Deceased was having a motor. Then the say जो theft ହେଇଥିଲା, that took place how many days?
About 2 months back.
2 months back. And then the evidence came that it was returned to
the father of the
right. Returned to the father of the deceased. Father, nahi, aa bappa taku ferei dela to.
Gotcha.
Father of the appellant to the father of the deceased or deceased?
Elder father.
PW2, your lordship.
PW. बाकी गोटे आसुची जो थ्रेड टा से थ्रेड विषय जो माने कहिसेंती केबे कहिसेंती से गुडा को केबे थ्रेड देला किछि नाही
सेटा ना
when that threat was given. Now ये गोटे पार्ट गला. Then comes at the instance of the accused one, sword was recovered. Sword रे जो blood मिलिला तारो येटा आसुची, that is what is that?
No opinion, inconclusive.
काई कोडा कड़ा केते नंबर ता?
84.
हाँ
84.
Sword hella blood अच्छी and no opinion. Sword blood no opinion. बाकी रहला हेयर ऊपर डिसीजन होची आउ कोन अछि अदे.
Lords, he was absconding for 12 days after the incident.
Absconding माने
It was not been discussed.
He was apprehended, or that is not been taken by the trial court, your lordship, this circumstance.
One circumstance, if your lordship will permit me, no explanation whatsoever was offered as to how the appellant has reached to the rooftop.
Yes, when
Exactly.
the wife of the deceased has admitted
And your
in
lordship.
para 33,
Again.
page 33,
Again.
the main gate was
I'm obliged.
closed, and ordinarily it is not expected that somebody will come to our house through the main gate when it is closed. The main gate was closed in the night of the occurrence.
main gate ଦେଇକି ନାଇଁ ଦେଖ ଯଦି
Staircase to be inside the house fully.
Interesting your lordship.
ତେଣୁ it is only possible if someone ଯଦି ତାଙ୍କର boundary ଥିବ, boundary jump କରିଥିବ, then କୋଠା ଉପରକୁ ଯଦି କୌଣସି ବାଟ ଥିବ ଚଢିକିନି ଯିବା, then it is possible.
ସେଟା ଆଉ ଟିକେ ଦେଖିଲେ ଆପଣ ଜାଣିପାରିବେ. Your lordship may kindly come to paragraph 4, page 68. Blood sample was collected from the staircase.
Yes.
That means someone who has committed murder has escaped through main door. And it is not
Yes,
possible
yes.
without aid and assistance of somebody inside the house.
ନାଇଁ staircase ଦେଇକିନି ମାନେ କୋଉଟା କହୁଛନ୍ତି?
Paragraph 4, page 68. Blood stain collected from the staircase and railing of the staircase. That means who has committed the crime, my lord, thereafter he has my lord, gone through the staircase, and staircase is inside the house.
No, that is all right. But one thing is that door ଉପର ଯୋଉ door ଯୋଉଠି ସେ ଛାତରେ ଶୋଇଥିଲା ସେଇଟା ଓପନ ଥିଲା, କାରଣ PW1 ନିଜେ ମଧ୍ୟ ଯାଇକିନି ଦେଖିଲା, ଅର୍ଥାତ୍ ଘର ଭିତର ଦେଇକିନି staircase ଦେଇ ଛାତରେ ପହଞ୍ଚିବାକୁ କୌଣସି କବାଟ ଦିଆହେଇନଥିଲା, ଅର୍ଥାତ୍ ସେ ଯୋଉ ଛାତ ଉପରେ ଶୋଇଥିଲା ଛାତର ସେ ଯୋଉ କବାଟ ଥିବ ବା ଯାହା ଯଦି ଥିବ ସେଇଟା କିଛି ବନ୍ଦ ହେଇନଥିଲା, ତେଣୁ ଜଣେ ଆରାମସେ staircase ଦେଇକିନି ଉପରକୁ ଯାଇ ପାରିଥାନ୍ତା, କାରଣ
ଯାଇପାରିବନି
ଥିଲା
କାରଣ staircase ଟା ଘର ଭିତରେ.
To collect the key, he has stated.
ଆଜ୍ଞା, staircase ଟା ଘର ଭିତରେ, staircase ଟା ବି ଘର ଭିତରେ.
ଗଲା ତା
wife ଗଲାନି କି staircase ଦେଇକିନି ପୁରା ଉପରକୁ ଯାଇ ଦେଖିଲା,
wife ଯାଇପାରିଲା.
ହଁ, ତା ମାନେ staircase କୁ ଯିବା ପାଇଁ ବା ଛାତ ଉପରକୁ ଯିବା ପାଇଁ ଯୋଉ ବାଟଟା ସେତେବେଳକୁ କୌଣସି ଗେଟ୍ ଫେଟ୍ ଦେଇକିନି ବନ୍ଦ ହେଇନଥିଲା, କାରଣ ଚାବି ତ ଥିଲା, ଚାବି ଯୋଉଟା ଥିଲା ସେଇଟା ହଉଛି
main door,
gate ର ଚାବି,
main door.
ତେଣୁ ଏଇ ଯୋଉ ଆପଣ ଇଏ କରୁଛନ୍ତି ହେଇପାରିବ ଯେ
ଘରେ ପଶିବା ପାଇଁ ତାଲା ଭଙ୍ଗା
ଏଇ ଯୋଉ fact remains that the occurrence or the death murder has taken place on the rooftop. ସେଥିରେ କିଛି dispute ନାହିଁ, କାରଣ scientific officer ବି ଯାଇଛନ୍ତି, inquest ବି ସେଇ rooftop ରେ ହେଇଛି, ଏବଂ blood stains ଗୁଡାକ ଯେହେତୁ ମିଳୁଛି ଏଠୁ କୋଉଠୁ ମାନେ railing ରୁ ଆଉ ସେଇ ଯୋଉ staircase ରୁ what you are submitting, it may be right that ଯିଏ ବି murder କରିଛି ତ ସେଇ ପଟ ଦେଇକିନି ଆସିଛି, ସେତେବେଳେ ରକ୍ତ ଫକ୍ତ ଲାଗିଥିବ, that is possible. ତେଣୁ ସେଇଥିପାଇଁ ତା ପରଦିନ how from this circumstance, Mr. Mishra,
Lordship.
how do you say that the chain is complete? ଏଇତିକି ଯେତି circumstance ଆସିବ, it FIR ରେ suspicion, how this is the nature of evidence adduced, ସେ ଯୋଉ motive ଟା ଦେଇଛନ୍ତି ତା ପାଇଁ ସେମିତି କିଛି clear cut evidence ଆସୁନି, ଆର motor ଥିଲା କି ନାହିଁ, ଥିଲା ଯଦି ଚୋରି ହେଇଥିଲା କେବେ ହେଇଥିଲା report ନାହିଁ, ତେଣୁ ତା ପାଇଁ ଯୋଉ threat ଯୋଉ ଦିଆ ହେଇଥିଲା ସେଇଟା 2 ମାସ ତଳେ ମାନେ କେବେ ଦିଆ ହେଇଥିଲା ଏଗୁଡାକ ବି ମାନେ ସେମିତି ନାହିଁ, ଆଉ ବାକି ଯୋଉ evidence ରହିଛି ଯଦି ଆମେ accept କରିବୁ ବି ଯେ ଗୋଟେ soap recovery ହେଇଛି ଯୋଉଥିରୁ blood ଥିଲା but origin ଜଣା ପଡୁନି, human blood କି ନୁହେଁ ସେଟା ଜଣା ପଡୁନି, ତେଣୁ sharp cutting weapon ରେ ସେ injury possible, but the question is that ଯୋଉ soap ଟା at the instance of the appellant ହେଇଛି, whether that particular sword was used for killing the deceased would have been relevant factor if the prosecution would have proved that. ତେଣୁ ସେଠି eye witness ଯେହେତୁ ନାହାନ୍ତି ଏବଂ grouping ଆସିଲାନି କିଛି,
अर्थात डिसीज्ड ब्लड ता धीरे लागिची तेणु सेठी बाकी हेयर रो जो गुड़ाक डिसीजंस आसिला बा ज्यूरिस्प्रुडेंस आसिला जे साइंस ऑफ आइडेंटिफिकेशन इक्विटी परफेक्शन है these are latest events ये मतलब apart from this all these decisions से कहउछन जे खाली तारी बेसिस रे छुट्टीटा मिलला particularly when से छुट्टीटा आपण ये कला परे सील करी रखिबार एविडेंस ही ना बुझला ना तेणु जदि ताकू सील न करिसेंती ताहले accused रो कलेक्शन हला परे सेई जिंस दीटा ये रखी देकिन पॉसिबिलिटी अछि जे सेटा को लिखि देबे एटा ताठू कलेक्ट हेतिला बोली हातरू आपण दीटा जमा ये स्ट्रैंड so दीटा हेयर जदि accused टू कलेक्शन हला पुळाय हेयर ताजुरु दीटा ताकू देखि देबे जे एटा कलेक्ट हेची ताठू जो फीस्ट रू आ बाकी एतिक सब कंपैरिजन ने टैली करि जिवो तेणु सेति पई सेइटाकू सील करिवार थिला एइटाकू भी सील करिवार थिला तो एइटा सील करिवार एविडेंस अछि आपण जो accused रो but where is the evidence that the other item was sealed and when it was sent for C examination
10 ମାସରେ ଯାଇଛି
ଆପଣଙ୍କର 22 6 ରେ ଆପଣଙ୍କର କଲେକ୍ସନ ହେଇଗଲା ଗୋଟେ ତ ହେଲା ସେଇ ଡେଟ୍ ଅଫ ଅକରେନ୍ସ ର ପର ଦିନ ଆଉ ବାକି ଆକ୍ୟୁଜ୍ଡ ର କଲେକ୍ସନ ହେଲା 22/6/2003 ର ତାପରେ ଆପଣ ତାକୁ ପଠେଇଲେ
12 ଦେଖ
ହଁ
ଲର୍ଡସିପ କାଇଣ୍ଡ 12 ପେଜ 70
ହଁ 18/10 ହଁ ପୁରା ସେଇଠି ଲେଖା ହେଇଛି ତା ଦେହରେ ରିପୋର୍ଟ ରେ ବି ତଳେ ଡେଟ୍ ଅଛି ଆଇ ଡେସ୍ପାଚ ଦିସ୍ ୱାନ୍ସ ତ ଏଇ ଯୋଉ 4 ମାସ ଧରିକିନି ସେଟା କୋଉଠି ଥିଲା କେମିତି ଅବସ୍ଥାରେ ଥିଲା
No, that was sent in a sealed packet, your lordship.
Huh?
Lordship may see the forwarding report.
नो ସିଲ୍ଡ ପ୍ୟାକେଟ ରେ ଯାଇଛି ବୋଲି କେହି ମନା କରୁନାହାନ୍ତି କାରଣ ଫରୱାର୍ଡିଂ ରିପୋର୍ଟ ରେ ଅଛି ଶୁଣନ୍ତୁ କ୍ୱେଶ୍ଚିନ୍ ଇଜ ଦ୍ୟାଟ ସିଲ୍ଡ ସେତେବେଳୁ କରିକିନି ରଖିଥିଲେ ଯେତେବେଳୁ ଜବତ ହେଲା ସେତେବେଳଠୁ ଯଦି ସିଜର ଏଭିଡେନ୍ସ ର ନା ସିଜର ୱିଟନେସ୍ କହୁଛନ୍ତି ନା ଆପଣଙ୍କର ଆଇଓ କହୁଛି ସେଟା ସିଜ୍ ହେଲା ବୋଲି ଏ ସିଲ୍ଡ ହେଲା ବୋଲି ସାଇଣ୍ଟିଫିକ ଅଫିସର କୁ ଆପଣ ଏକ୍ସାମିନ କଲେନି
That is not reflected in the seizure list also, lordship. Exhibit 2.
ହଁ
Is it not reflected
No.
there? I don't have a copy of the
नो
seizure.
नो ଦ୍ୟାଟ ଇଜ ଏଇ ଏଟା ବାହାର କଲ ସେ ସିଜର ଲିଷ୍ଟ exhibit 2 ବାଦ ହେଇଗଲା circumstance of seizure ଏହା ଲେଖା ହେଲା ଉପରୋକ୍ତ ମକଦ୍ଦମାର ତଦନ୍ତ କରୁଥିବା ସମୟରେ ଘଟଣା ସ୍ଥଳରୁ ସାଇଣ୍ଟିଫିକ ଅଫିସର ନିମ୍ନଲିଖିତ ଜିନିଷ ମାନ ସଂଗ୍ରହ କରି ଘଟଣା ସ୍ଥଳରେ ସାକ୍ଷୀ ମାନଙ୍କର କଣ ସାମ୍ନାରେ ଦାଖଲ ଦେବାରେ ତାହା ଜବତ କରାଗଲା ହେଲା ତାପରେ 1 exhibit A ଲେଖା ହେଇଛି blood stain collected on the gauze cloth from the swan so near the head of the deceased ତାପରେ ସେମିତି exhibit B ଟା ବି ହଉଛି blood stain C ଟା ବି ହଉଛି blood stain collected from the cement railing of the staircase then exhibit D ହଉଛି important ଏଇ case ରେ exhibit D is the hair pieces collected from the belly and right palm of the deceased total କିଛି ନାହିଁ କୌଣସି ସିଲ୍ଡ ହେଲା ବୋଲି ସିଜିଅର ଲିଷ୍ଟ ରେ ନାହିଁ ବାକି ଆପଣଙ୍କର ଆଇଓ ର ଏଭିଡେନ୍ସ ରେ ନାହିଁ ବାକି ତାର ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ୱିଟନେସ୍ କିଏ ଅଛନ୍ତି କି
PW2.
Not over Rao.
Again.
Kiye?
Again.
So he has
ନା,
also
ନାଇଁ,
not stated
Brahmara
about
Varda.
ଭ୍ରମର ବରଦାସ ହେଇଛି। ଭ୍ରମର ବରଦାସ ସିଏ କିଛି କହୁଛି ସିଲ୍ ଫିଲ୍ କଥା।
no,
Nah,
he
nah.
has not stated about this.
এইটা তো টোটাল ନାହିଁ ମାନେ ଯୋଉଟା human power ଟା ଯୋଉଟା two strands of happiness and then human
ଡାକ ତମ ଲେଖିବ ହଁ ଲେଖ।
Lordship, may I only submit a few more
Yeah.
points on the hair,
Yeah.
because that is the most crunching piece of
Mm.
evidence in my opinion, Lordship. If your Lordship may take that report for one last time.
ସୁପ୍ରିମ କୋର୍ଟର ଡିସିସନ ରହୁଛି ଯୋଉଟା ମୁଁ ଦେଖେଇଲି
Lordship,
ଯେ ଆପଣଙ୍କର ଯଦି ଅନ୍ୟ ଏଭିଡେନ୍ସ ଥିବ ତାହେଲେ ଏଇଟା ଗୋଟେ ଆଡିସନାଲ ଫ୍ୟାକ୍ଟର ହିସାବରେ ନିଆଯାଇପାରେ।
yes,
ଏଇଟା ସାଇଣ୍ଟିଫିକ ମୋଦି ଜୁରିସ୍ପ୍ରୁଡେନ୍ସ ଲାଟେଷ୍ଟରେ ମଧ୍ୟ କହୁଛି ଏଇଟା ଗୋଟେ ଏ ସାଇନ୍ସଟା ପରଫେକ୍ସନ କୁ ଆସିନି।
Lordship.
ଲାଇକ୍ ଫିଙ୍ଗର ପ୍ରିଣ୍ଟ ଆପଣ ପରଫେକ୍ସନ ଆସିନି, DNA ଟେଷ୍ଟ ଏଗୁଡା ସବୁ ପରଫେକ୍ସନ କୁ ଆସିଗଲାଣି। ବଟ୍ ଏଇ ଯୋଉ ହେୟାର ରୁ ଜଣକୁ ଜଜ୍ କରିଦବା ଯେ ଇଏ ତାର ରିଜିନ୍ସ ଦେଇଛନ୍ତି କଣ ପାଇଁ ଆସିନି ପରଫେକ୍ଟ, ଡାଇଂ ହଉଛି ଇଏ ହଉଛି, ତାପରେ କଣ କଣ ଆଉ ଗୋଟେ ସବୁଠୁ ମୋଷ୍ଟ ଇମ୍ପୋର୍ଟାଣ୍ଟ ଥିଙ୍ଗ ହଉଛି ଯେ what you are to do when you uh, are asked for chemical examination, what you are to do, ତାର ସାଇଜ ମାପିବ, ତାର ଇଏ ରୁଟ୍ ଅଛି ନା ନାଇଁ ଦେଖିବ, ତାର କୋଉ ଟାଇପ ର ମୋଡା ହେଇଛି, କାରଣ କାର ଯଦି କର୍ଲ ହେୟାର ଥିବ ହେଲା ସେ ଟାଇପ ସେଟା କୋଉ ଟାଇପ ର ତାକୁ ଡାଇମିଟର ଇଏ ଏଗୁଡା ସବୁ ମାପିବ। ମାପିଲା ପରେ ମାଇକ୍ରୋସ୍କୋପିକ ଏକ୍ସାମିନ କରିକି the science of comparison of hair has not yet reached perfection like the science of comparison of fingerprints. Where the scientific officer posted in the forensic science laboratory had not carried out the test meticulously, did not measure the diameter of the shafts of the hair or their length, 1. 2. Take impression of the cuticles of the hairs. Number 3. Note the shapes, appearance, and colors of the hair. Direction of pointing out of the hair. It would be unsafe to rely upon his report.
Yes.
So these are things it is to be noted down ଯେ ତମେ ଖାଲି ଟାଲି କହିଦେଲେ ଲେଖିଦେଲେ ହବନି, ତମେ କୋଉ କୋଉ ବେସିସ ରେ ମାନେ ଏକ୍ସପର୍ଟ ର ଏଭିଡେନ୍ସ ର ଆକ୍ସେପ୍ଟ ପ୍ରିନ୍ସିପଲ ହଉଛି ତମର ମେ ବି ଏ ହ୍ୟାଣ୍ଡରାଇଟିଂ ଏକ୍ସପର୍ଟ, ମେ ବି ଏ ଫିଙ୍ଗର ପ୍ରିଣ୍ଟ ଏକ୍ସପର୍ଟ, ସେମାନେ ମଧ୍ୟ ତାଙ୍କର ରିପୋର୍ଟ ସହିତ ତାଙ୍କର ରିଜିନ୍ସ ଦେବେ ଯେ ଏଇ କାରଣ ପାଇଁ ଆମେ ଆରାଇଭ କଲୁ, ମନେକର ଫିଙ୍ଗର ପ୍ରିଣ୍ଟ ରିଜେସ୍ ଏଇଟା ଆମକ ସାଙ୍ଗରେ ମ୍ୟାଚ୍ କରୁଛି, ସେଇଟା ତା ସାଙ୍ଗରେ ମ୍ୟାଚ୍ କରୁଛି, ଆମକୁ ଏଇଟା ତେଣୁ ତାର ଲୁପ୍ ହୋଲ ହେଉଛି ଏଇଟା, ଏଇ ସବୁ ଜିନିଷ କଲା ପରେ ଦେନ୍ ଏଇଠୁ କମ୍ପାରିଜନ କରି ସୋ ଅନଲେସ୍ it is a mere export evidence, ସେଥିପାଇଁ କୁହାଯାଇଛି କୋର୍ଟ ଇଜ ଏକ୍ସପର୍ଟ ଅଫ ଏକ୍ସପର୍ଟ। କୋର୍ଟ ଦେଖିବ ସେ ଯୋଉ ରିଜନ୍ସ ଦେଇଛନ୍ତି, court may accept that reasons and then accept the finding also. Court may say that no, this ତେଣୁ without any reasons ଖାଲି ଆପଣ ଦେଇଦେବେ ଯେ ଟାଲି କରିଗଲା, that would not be। କଣ କଣ ଏକ୍ସାମିନ କଲେ ଏବଂ ତା ବେସିସ ରେ ଆରାଇଭ କଲେ ଫାଇଣ୍ଡିଂ ତାକୁ ଦବାକୁ ପଡିବ, and it should also be kept in mind that it has not reached perfection। ଏପର୍ଯ୍ୟନ୍ତ ଲାଟେଷ୍ଟ ରେ ମଧ୍ୟ perfection ଆସିନି, ତେଣୁ that is one aspect। Number 3, ଏଭେନ୍ସ ଡିସିସନ୍ସ କହୁଛନ୍ତି ଯେ ଯଦି ବି ଟାଲି କଲା ସେଇ ବେସିସ ରେ କନଭିକ୍ସନ ହବନି, ଅନ୍ୟ ସର୍କମଷ୍ଟାନ୍ସ କ୍ଲିଞ୍ଚିଂ ଏଭିଡେନ୍ସ ଦରକାର ଯୋଉଟାରେ ଏଇଟା ହୁଏ ତ ତମେ ଆଡିସନାଲ ୱେରେ ନବ। ତେଣୁ ଆପଣଙ୍କର ଏଇଟାକୁ ଯଦି ଲେଟ୍ ଅସ୍ ଆକ୍ସେପ୍ଟ ଦ୍ୟାଟ ଏଇଟା ଟାଲି କରିଗଲା, ବଟ୍ ଅଦର ଏଭିଡେନ୍ସ ଯଦି ଆପଣଙ୍କର କିଛି ନାହିଁ ତାରି ବେସିସ ରେ particularly when the most important aspect which is lacking that after its seizure it was sealed. ताल तो tampering करिया बहुत easy है जीवो ना. आपण accused रो hair collect कर देवे, ताकू देखेई देवे deceased रो fist रू जबत हला. हला आ बाकी accused रो ये collection हला परे दीटा को दीटा sealed packet करी पठेई देवे, लिखी देवे ये बेली. तेणु ଯେତେବେଳେ seizure ହବ ସେଠୁ on the spot scientific officer it should be sealed in presence of the witness, sealed ହବ properly, paper seal ଦିଆଯିବ ତା ଦେହରେ witness ମାନେ ଇଏ ରେବେ ଯେମିତି seal ର ଯୋଉ procedure ଗୁଡାକ ଅଛି ହେଲା seal ଦିଆଯିବ ତାହେଲେ tampering ଆଉ ହେଇପାରିବନି ସେଟା ଗୋଟେ authentic ହେଇ ରହିଲା. ତାପରେ ଯେତେବେଳେ accused ଆସିଥାନ୍ତା ତାର ସେମିତି collection ହେଇଥାନ୍ତା ଯେମିତି ଏଠି ହେଇଛି. then ଏଇ ଦିଟା ଯାକୁ ପଠା ହେଇକିନି comparison ହେଇଥାନ୍ତା. ଏଠି ପ୍ରଥମ ଜିନିଷଟା ଯୋଉଟା ସାଇଣ୍ଟିଫିକ ଅଫିସର ଆସିଲେ ଆପଣଙ୍କୁ କଲେକ୍ଟ କରିଦେଲେ ଆଇଓ କୁ ଦେଇଦେଲେ ସିଏ ତାର ପଳେଇଲେ ଗଲା. ଆଇଓ ର କିଛି ଏଭିଡେନ୍ସ ନାହିଁ ସିଏ ତାକୁ କଣ କଲା ତାକୁ ସିଲ୍ କଲା କି କଣ କଲା କିଛି ନାହିଁ. ତେଣୁ ହାଉ ଦିସ୍ କୋର୍ଟ would be convinced that it was the very same hair which was collected from the fist of the deceased that was sent for CE examination.
Lords,
and had consumed this near so village, and thus he led us to the spot and in presence of the witness, we have discovered the shoulder of so and execution of so.
नहीं see so that recovery unless it is linked with the crime. Why do its recovery becomes a फ्लड नहीं पर माने এটা ଦେଖିଲେ ପରେ এই ଯୋଉ ସି ରିପୋର୍ଟ ରେ ପେଜ ନମ୍ବର ସେ ପଏଣ୍ଟ ଆଉଟ୍ କରୁନି ଯେ that is ରିପୋର୍ଟ ହଉଛି এটা ହଉଛି ରୋଡ ନା ଏଟା ଆଇଟମ ନମ୍ବର ପେଜ 81 ରେ ଅଛି ସେ ଆଇରନ୍ ଏଟା देखो ब्लड पेंट नो ओपिनियन माने ओरिजिन भी किसी जଣା पड़लानी आ ग्रुपिंग कथा तो सहजरे छाड़ो इनकनक्लूसिव तेणु गोटे ब्लड लागी से ब्लड कहार ब्लड मनुष्यर कि कहार ओरिजिन जଣା पड़लानी ग्रुपिंग भी नाही तेणु हाउ इट विल बी कनेक्टेड विथ द क्राइम इन क्वेश्चन गोटे सोटे जबती जोथरे किछि ब्लड लागितला से ब्लड टा को ओरिजिन किछि नाही. So even if that is also that recovery becomes immaterial. Yes, what is your submission?
Lords, so far as the report is concerned,
Which report?
that report on the similarity of the strands of hair, Your Lordship.
No, once we entertain doubt that the prosecution has not adduced any evidence regarding sealing of the pair, we will just ignore the report about the finding because unless you ମନେ କରନ୍ତୁ ଆପଣଙ୍କର ଗଞ୍ଜାଟା ଜବତ ହେଲା ଗଞ୍ଜାଟା ଗୋଟେ ଜିନିଷ ଜବତ ହେଲା ଯୋଉଟା କି ଅଲ୍ଟିମେଟ ଫାଇଣ୍ଡିଂ ହେଲା ଯେ ଏଇଟା ହଉଛି ଗଞ୍ଜେଇ ବୋଲି ବଟ୍ ଯଦି ଆସିଲା ଯେ ଆ ଦେହରେ ଟ୍ୟାମ୍ପରିଂ ହେଇଯାଇଛି ଏଭିଡେନ୍ସ ଆପଣ କ୍ଲିଞ୍ଚିଂ ଏଭିଡେନ୍ସ ନ କଲେ ଯେ ଏଇଟା ସିଲ୍ ରେ ରହିଥିଲା ସେଫ୍ କଷ୍ଟଡିରେ ରହିଥିଲା ହେଲା ତେଣୁ ସେଥିପାଇଁ ଡିସିସନ୍ସ ଗୁଡା କହିଲା ଯେ ରାଇଟ୍ ଫ୍ରମ୍ ଦି seizure till it is examined by the expert ଏଇଟା ତାର ଏଣ୍ଟାୟାର ପାଥ ଟା ଗୋଟେ କନଭିନ୍ସିଂ ୱେ ରେ ଯିବ ଗୋଟେ ମ୍ୟାଟେରିଆଲ ଏମିତି ଆସିବା ଦରକାର ଯେ ଦେयर ୱାଜ नो चांस ऑफ टैंपरिंग विथ द सेम ସେଇଥିପାଇଁ କୁହାଲା ଯେ ସେ ଟାଇପ ର କେସ ରେ ସିଲ୍ ହବ ସେ ଯୋଉ ସିଲ୍ ଟାକୁ ସେଟା ଗୋଟେ ଥାର୍ଡ पर्सन କୁ ରହିବ ରିଲାଏबल पर्सन କୁ ରହିବ ସେଟା ଯେତେବେଳେ ପ୍ରଡ୍ୟୁସ ହବ କୋର୍ଟ ରେ କୋର୍ଟ କମ୍ପେୟାର କରିବ ଯେ ଏଇ ଯୋଉ ସିଲ୍ ଟା ଦିଆ ହେଇଛି ସେଟା ଏ ସିଲ୍ ସାଙ୍ଗରେ ଟାଲି କରୁଛି ନା ନାହିଁ ନା ଆଉ ତାକୁ ଟ୍ୟାମ୍ପରିଂ କରିଦେଇଛନ୍ତି ତାପରେ ସ୍ପଟ ରେ ଗୋଟା ହେଲା ପରେ पेपर सिल दिया पेपर सिल दिया कहीं पेपर सिल मारले टैंपरिंग कर पेपर चिरी जीवो विटनेस मानकर सिग्नेचर विभिन्न जिनस प्रोसीड्योर एवं जितेबाला कोर्ट रे प्रोड्यूस हो कोर्ट ऑर्डर शीट रे नोट डाउन करिवो जे इट वाज फाउंड टू बी सील्ड ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ବାଟ ଦେଇକି ଗଲେ ଏବଂ it should be immediately done, not that you keep it for an indefinite period and at your whim and pleasure you produce it. ଏଇ ବାଟ ଗୁଡାକ ଦେଇକିନି ଗଲା ପରେ ଯଦି ରିପୋର୍ଟଟା ଆସିଲା, ସେ ରିପୋର୍ଟର ସାଙ୍କ୍ଟିଟି ଅଛି। ଯଦି ମୂଳରୁ ଆସିଲା ଯେ ସିଲିଂ ର କିଛି ଏଭିଡେନ୍ସ ନାହିଁ, then the report becomes inconsequential. Report cannot be acted upon, right? So,
May I, my lords, stretch my argument to this extent?
yes,
That because in the forwarding report, it was clearly mentioned that the exhibit was sealed, your lordship. So therefore, the presumption can be
exhibit,
taken.
no, it was sealed when it was produced in court. It was sealed when it was produced in court and it was forwarded to the for scientific examination. But it cannot say that it was sealed right from the beginning because the evidence is lacking. Dita difference kon buchon to.
Lordship.
So October masere ଯେତେବେଳେ କୋର୍ଟ ରେ ପ୍ରୋଡ୍ୟୁସ ହେଲା, ଫରୱାର୍ଡିଂ ରିପୋର୍ଟ ରେ ଲେଖା ହେଇଛି ହେୟାରଟା ସିଲ୍ଡ ଥିଲା, ଠିକ କଥା, ସେ ସିଲ୍ଡ ଥିଲା। ଜବତ ହେଇଛି ଜୁନ ମାସରେ, ଆପଣଙ୍କର ସାଇଣ୍ଟିଫିକ ଅଫିସର ଏକ୍ସାମିନ ହେଲେନି, ଯୋଉ ଦି ଜଣ ୱିଟନେସ ଏକ୍ସାମିନ ହେଲେ, ଗୋଟେ ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ୱିଟନେସ ଆଜ PW2 ଆଉ ଆପଣଙ୍କର IO PW14, କେହି କହିଲେନି ଯେ ଜବତ ହେଲା ପରେ ଆକୁ ସିଲ୍ଡ କରିକିନି ରଖାଗଲା। ଆପଣଙ୍କର ସିଜିଅର ଲିଷ୍ଟରେ ମଧ୍ୟ ଏ ଉଲ୍ଲେଖ ନାହିଁ। ତେଣୁ ଆଣ୍ଡ କୋଉଠି ଥିଲା ସେ ହେୟାରଟା, ଏ ଯୋଉ ଦିଟା ହେୟାର କୋଉଠି ଥିଲା, କାହା କଷ୍ଟଡିରେ ଥିଲା? କାରଣ ଯେତେବେଳେ ସିଜିଅର ହେଇକିନି ରଖାଯାଏ, ସେଟା ମାଲଖାନାରେ ରଖାଯିବା ଉଚିତ। ମାଲଖାନା ରେଜିଷ୍ଟରରେ ଏଣ୍ଟ୍ରି ହବ, ସିଲ୍ଡ ଅବସ୍ଥାରେ ରଖାଗଲା। ମାଲଖାନାର ଯେତେବେଳେ ନିଆଯିବ, ସେଟା ପୁଣି ଆଉ ଗୋଟେ ଏଣ୍ଟ୍ରି ହବ ଯେ ଏଠୁ ମାଲଖାନାରୁ ବାହାରିଲା ଏଇ ଦିନ। These are the ways to connect for the safe custody. କିଛି ଏଭିଡେନ୍ସ ନାହିଁ। ତେଣୁ ଆପଣ ଯୋଉଟା ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି ଯେ forwarding report, it has been mentioned that the hairs were produced in sealed condition. It's right, it was produced, but that cannot be, we cannot conclusively held that merely because it was produced in sealed condition, it was sealed right from the beginning 4 months back when it was seized. Because the evidence is lacking, it is your duty. Prosecution duty is to adduce evidence that right from the beginning, when the seizure was made, that was sealed and it was kept in safe custody. There was no chance of tampering with this. Evidence নহলে report becomes inconsequential. ମୁଁ ଆପଣଙ୍କୁ ଉଦାହରଣ ଦେଲି, ଆରେଷ୍ଟ ହେଲା ପରେ ଆର ଆକ୍ୟୁଜ୍ଡ ର ବାଳ କଲେକ୍ଟ କଲେ, ତାକୁ ଗୋଟେରେ ସିଲ୍ଡ ଦେଖେଇଦେବେ ଏଇଟା ହଉଛି ତା ହାତରୁ ଜବତ ହେଲା, ଆଉ ଗୋଟେ ଦେଖେଇଦେବେ ଏଇଟା ଆକ୍ୟୁଜ, କମ୍ପାରିଜନରେ ଚାଲି ଆସିବ, ମିଶିଯିବ। and again decision says that ଖାଲି ହେୟାର ଟାଲି କରିଗଲା, ଆଉ କିଛି ଏଭିଡେନ୍ସ ନହେଲେ ତାକୁ it's very unsafe to convict an accused. 302 ରେ ଆପଣ ଲାଇଫ ଇମ୍ପ୍ରିଜନମେଣ୍ଟ ଦଉଛନ୍ତି, କୋଉ standard ର proof ହବା ଦରକାର, that has been laid down in a case of circumstantial evidence, ଶରତ ବିଲଚାନ୍ଦ ସାରଦା। ତେଣୁ ସେଠି କହିଛନ୍ତି ଯେ circumstances taken together must form a complete chain. ଏଠି ଚେନ୍ ହିଁ କାହିଁ ଆପଣଙ୍କର, କମ୍ପ୍ଲିଟ ଚେନ୍ ଛାଡ, ଲିଙ୍କ, ପ୍ରତ୍ୟେକ ଲିଙ୍କ କୁ ଆପଣ ଏଷ୍ଟାବ୍ଲିଶ କରିବେ, that cannot be explained under any other hypothesis. It should form a complete chain and that must point unerringly to the guilt of the accused. ତାହେଲେ ଯାଇକିନି ଆପଣଙ୍କର circumstantial evidence ରେ conviction ହେଇପାରିବ। ଏଠି କିଛି ନାହିଁ ଆପଣ।
But even we put aside the matching of the hair strand part, your lordship, the motive is still there, your lordship, that PW1, 2, and 3 have stated, and that has not been completely challenged in the cross-examination also, that the motor was stolen and then there was a dispute regarding that, and he threatened to kill the deceased after the motor was stolen, your lordship, as per PW1.
That occurrence took place about 2 to 3 months back.
2 months
back.
back.
Yes.
But it is quite natural that he would have gotten enraged again, because just 2 days prior to the date of incident, the father of the accused has returned the motor to the deceased, your lordship.
So matter subsided. So how, what is the
but
motive?
it was not the accused himself who returned it.
Accused who
So-
ki jiyo, tanko
So
ani
the willingness, the willingness of the accused to return it and subside the matter is not there. Your Lord.
ସେମାନେ କୋଉ source ରୁ ଆଣିଲେ କେମିତି ଜଣା ପଡିବ? ସେମାନେ କଣ କହିଛନ୍ତି କି ଆମେ ସେ ଆଣିକିନି accused ମାନେ ରାଜି ନଥିଲା ସେ ମୋଟର ଫେରେଇବାକୁ, ଆମେ ଆଣି ତାଠୁ ଜବରଦସ୍ତି ଫେରେଇ ଦେଲୁ, accused ବହୁତ ଏମିତି କିଛି ଅଛି କି evidence? ସେ ଆଣି
But the
ମୋଟରଟା
evidence,
ଫେରେଇ ଦେଲେ।
the evidence is that it came through the father of the accused. Your
ହଁ,
Lord.
ହଁ,
The motor was returned through the father of the accused. Your
right,
Lord.
right. Father of the accused ଆଣିଲା ବେଳେ accused ର କିଛି expression ଥିଲା, ତାଠୁ ଜବରଦସ୍ତି ଆଣିଲେ, ସିଏ ରାଜି ନଥିଲା, ସେଥିପାଇଁ ଆପଣଙ୍କର very risky in that. Another thing which is pointed out by my esteemed brother,
Okay.
that ଘରର main କବାଟ ବନ୍ଦ ଥିଲା, right? ଯୋଉ gate ଟା ବନ୍ଦ ଥିଲା, ଚାବି ପରା accused deceased ପାଖରେ ଥିଲା।
Deceased ପାଖରେ।
ତ ଯିଏ ବି ଆସିଛି ସିଏ obviously ସେ gate ଦେଇକି ତ ଆସି ନଥିବ, ତ ସିଏ access ତାର ହେଇଥିବ, ଆଉ ବାଟ ହଉଛି କୋଉ ଅନ୍ୟ କୋଉ ପଟେ ଚଢି ଛାଡିକିନି ଉପରକୁ ଯାଇଥିବ, ଯଦି ବାହାର ଲୋକ ଏ କ୍ରାଇମ କରିଥିବ। ହେଲା, ବାହାର ଲୋକ ଯଦି କ୍ରାଇମ କଲା, ତାକୁ ମର୍ଡର କଲା, ସିଏ ଘର ବାଟ ଦେଇକିନି ଆସିପାରିବ ନାହିଁ, କାରଣ ବାଟ ବନ୍ଦ ହେଇଛି କବାଟ, ତ ସେଇ ପଟ ଦେଇକିନି ଡେଇଁକିନି ଯାଇଥିବ, ଯୋଉ ପଟେ ଆସିଛି ଚଢିଛି ଛାତ ଉପରୁ, ସେଇ ଛାତ ଡେଇଁକିନି ଯାଇଥିବ। ତାହେଲେ ଏଇ ଯୋଉ ଏଠି ରକ୍ତ କେମିତି ଆସିଲା staircase, that supposes that somebody from the family might have committed the murder.
Lords, one more
And
hypothesis could be, Your Lordship.
yes,
Because it is not concretely established that whether someone can jump from outside or climb
ଆଉ
from
ଯିବ
outside.
କେମିତି? ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ହଉଛି ଆଉ ବାଟ କିଛି ନାହିଁ। ଯଦି ମେନ୍ କବାଟଟା ବନ୍ଦ ହେଲା କୋଠା ଉପରକୁ, ବାଟ ହଉଛି ଏଇପଟେ ଯିବ, ନଚେତ କୌଣସି ପଟେ ଯଦି ଚଢିକିନି ଯାଇପାରିବ,
Lordship.
ପାଚେରୀ ଡେଇଁକିନି, ତାପରେ ଯଦି ଇଏ କିନି କୋଠା
Turn to page 86 of the paper book.
ଆପଣ ସ୍ପଟ ମ୍ୟାପ ଟା ଦେଖୁନାହାନ୍ତି, ସେଇ
Lordship.
ଏଣ୍ଟ୍ରାନ୍ସ ଡୋର ଟା ଦେଖନ୍ତୁ ବନ୍ଦ ଥିଲା, ଯୋଉଟା କି ଏଣ୍ଟ୍ରାନ୍ସ ଡୋର ଦେଖଉଛେ, ହେଲା।
It opened veranda.
See, he could have, my humble submission, what the hypothesis I'm trying to submit is, he could have climbed from outside the building onto the terrace.
ସିଏ ଘର ଭିତରୁ କାଇଁ
ଘର
ପଶିବ?
ଭିତରେ କାଇଁ ପଶିବ?
He would have tried to go outside through the interior of the house.
No, no, no.
Then finding the door locked, he had no other option but to climb down again, which is possible because the wife of the deceased.
It is not believable. Somebody, once he entered inside, means there is chance of other persons may notice him. He had come outside and he would commit the murder and go outside. Why he would enter into the house? And bloodstain would come in the staircase out the year. Somebody has କିଛି ଏଭିଡେନ୍ସ ବି ନାହିଁ, ସେ ତାର ମାନେ ଏଇଟା ଯୋଉ କହନ୍ତିନି ଓପନ କୋଠା ଥିଲା କି ତା ଭିତରେ ମାନେ ଇଏ ଥିଲା, ତାର ଚାରିପଟେ ୱାଲ୍ସ ଥିଲା, କିଛି ଏଭିଡେନ୍ସ ନାହିଁ। ଯାହା ବି ହଉ, ଛାତ ଉପରେ ମର୍ଡରଟା ହେଇଛି।
गोटे गोटे access with କୌଣସି ଖିଡିକି ବା ଅନ୍ୟ କୌଣସି ପାଇପ୍ ଫାଇପ୍ ଧରିକି ଯାହା ବି ହଉ
ଚଢି ଯାଇଥିବ।
ଉଠି ଯାଇଥିବ ବଟ୍ ଉଠିଗଲା ପରେ ସେ ଘର ଭିତର ଦେଇ କାହିଁ ଆସିବ? ଘର ଭିତରେ ତ ବନ୍ଦ ହେଇଛି। ହଁ, ଗେଟ୍ ଟା ଏଠୁ ଜଣା ପଡୁଛି ଏଣ୍ଟ୍ରାନ୍ସ ରୋଡ ବନ୍ଦ ହେଇଛି। ତେଣୁ ବନ୍ଦ ବି ଥିଲା, ସେଇଥିପାଇଁ ସେ ଚାବି ଆଣିବାକୁ ଗଲା, ଦେଖିଲା ମର୍ଡର ହେଇକି ପଡିଛି।
And the wife could jump from the rooftop.
ହୁଁ,
Wife could jump from the rooftop.
Yes.
ଜମ୍ପ
So-
ହେଲା ବା ସେ ଯାଅ। ହଁ, ତେଣୁ
No,
But she
herself
went-
has stated in the FIR.
Again,
The PW2 also has stated so, who is the neighbor
again.
of the deceased, has that wife jumped from the roof. But the wife who was deposed as PW1, she stated that seeing so dead body of the
she became senseless
she
and
became senseless and fell down.
down. ତେଣୁ it's what you are driving at, that it's very difficult that
PW2 stated that she jumped from the roof and thereafter she became senseless.
Not sure.
ଏଗୁଡାକ ସେଠି ମେନ୍ ଜିନିଷଟା ଡାକିଲି। ଏଇ ସରକମଷ୍ଟାନ୍ସ ଗୁଡା କୋଉଠି ରିଲାଏ ହେଇଛି, କୋଉ ପାରାଗ୍ରାଫ ରେ?
Millard. Judgment.
ହଁ,
Let's see. That is page 6. Page 6.
ସରକମଷ୍ଟାନ୍ସ ଗୁଡା କଣ କଣ?
Page 6.
Page
6.
6 ମାନେ internal
No, internal page 3.
page 3.
Roman 2.
Yes.
ନାଇଁ ଆପଣ ଯୋଉ ସରକମଷ୍ଟାନ୍ସ ଗୁଡାକ ଲେଖିଲେ
Again.
ସେଗୁଡା କୋଉଠୁ ପାଇଲେ?
About notes of submission.
Again. Accused had prior enmity, my lord.
ମାନେ ସେମିତି କିଛି ସରକମଷ୍ଟାନ୍ସ ଗୋଟେ ଜାଗାରେ ଏନ୍ୟୁମରେଟ୍ ହେଇଛି କି?
ହଁ ହେଇଛି ଆଜ୍ଞା।
କୋଉଠି?
page 10 enmity ଅଛି। ଆଜ୍ଞା।
ଏକାଠି କୋଉଠି ହେଇଛି, ତାପରେ ସରକମଷ୍ଟାନ୍ସ
ନାଇଁ ସେମିତି କରିନାହାନ୍ତି। I have summed it up.
not something. The following circumstances appear on record against the appellant. Roman 1. The appellant had prior enmity with the deceased in connection with the theft of a motor. On the basis of the statement of the appellant, the sword was recovered. Roman 3. And the FSL report indicated that faint bloodstain was found the sword. Roman 3. Hair struck in the right palm of the deceased was chemically examined and it was found to be tallying with that of the hair of the appellant. So far as the first circumstance is concerned, in the first information report is mentioned that in connection with the theft of a motor, the appellant had given threat to the deceased to kill. And it is further mentioned that one poor villager named Puni alias Sumant or Autrar had also threatened to kill the deceased on account of family dispute. In his evidence, the informant bracket PW1 has stated that he suspected the appellant to have committed the murder as the appellant had committed theft of their motor. And when the deceased asked about the commission of theft to the appellant, such threat was given. He further stated that she also suspected Puni alias Natavar Rao as he was looking after their crop and there was dispute between Puni and the deceased. In the cross-examination, however, PW1 has stated that no report was lost before police relating to commission of theft of motor by the accused and recovery of the same. And that she had not shown any document to the police that they had a motor. PW2 has stated that prior to 2 months of the occurrence, there was commission of theft of motor of the deceased. And for that reason, there was exchange of words between the appellant and the deceased. And when it was decided that the matter will be reported to the police, the father of the appellant told to search the motor, and accordingly, he returned the motor to him, which was handed over to the deceased. In the cross-examination, no report was given to the police regarding commission of theft, and no panchayat was also convened in connection with the theft of the motor of the deceased. And he could not say the make of the motor and when the motor was purchased. And he further stated that he had not heard about the appellant and the deceased exchanging words in connection with the theft of the motor. PW3 Narsingh Das has stated that 1 month prior to the occurrence, there was commission of theft of their motor. So PW3 so is the father of the deceased person. And when he asked the appellant about such theft, the appellant abused him in filthy language. And the deceased reached there and protested the action of the appellant. And then the deceased also told to report the matter to the police station. But the father of the appellant told not to report, saying that he would search for the motor. He further stated that in the night following the occurrence, a confrontation centered to the commission of theft of motor, and the father of the appellant told the ward member either to return the motor or to pay rupees 2,000 towards the cost of the motor. And on the next day, the brother and the father of the appellant returned the motor to the ward member. And for that reason, the appellant had threatened to kill the deceased. In the cross-examination, PW3 has stated that he had got documents to show the possession of the motor, but the same was not given to the police, and he could not say the make of the motor and when it was purchased by the deceased. And he also could not say the detail of the purchase of the motor. Therefore, these three witnesses who have stated about the motive behind the commission of crime or threat of given by the appellant to the deceased in connection with the theft of the motor, in our view, is very shaky in nature. First of all, the documentary evidence relating to the purchase of the motor is not produced, and no report was given before the police station in that respect, and there is no clinching evidence on record that the accused committed the theft of the motor. And if the motor had already been returned to the deceased on the next day of theft, as stated by PW3, there is no material as to why thereafter there would be any kind of grievance of the appellant with the deceased, particularly when there is no material from which source the brother and the father of the appellant brought the motor and handed over to the deceased, and that it was against the willingness of the appellant. Therefore, since in a case of circumstantial evidence, motive assumes pertinent significance, and the evidence relating to the motive which has been adduced by the prosecution is shaky in nature, we are not inclined to accept such evidence. The next circumstance that is relied upon by the prosecution is that of recovery of the sword at the instance of the appellant. Even if the IO evidence and the evidence of other witness is accepted in that respect, but there is no material before us that that particular sword was used in committing the murder of the victim. The sword was sent for chemical examination, and the C report by Exhibit 18 indicates that though Bloodstain was found in it, but the origin of the blood could not be detected, and the grouping was not done because it was inconclusive in nature. Therefore, this circumstance no way helps the prosecution in arriving at the guilt of the accused. So far as the hair stock in the right palm of the deceased is concerned, it is the prosecution case. The scientific officer visited the spot which was the rooftop of the deceased, and as per seizure list and uh, from the belly and hand of the deceased, some hair pieces were collected, and so also from the right palm of the deceased. And the scientific officer handed over to the same to the IO bracket PW14, which was seized as per seizure list Exhibit 2. In this respect, the scientific officer has not been examined in court, and though the IOs also, how would a case Saki Pala?
Two.
PW2.
PW2 has stated about the seizure of the hair from the right hand palm of the deceased, but there is no evidence that after its seizure it was kept in sealed condition. None of the witnesses has stated in that respect. Even the seizure list also doesn't indicate about the sealing aspect. The Mr. S.K.MISHRA Land Council, Additional Standing Council submitted that when the hairs were produced in separate covers, those were found to be sealed, and therefore it is to be presumed that after its seizure by the scientific officer, it was kept in sealed condition. We are not inclined to accept such submission, since the date of seizure of the hair was on 9/6/2003, and it was produced in court and forwarded for C examination on 18/10/2003 as deposed to by I. And there is no material before us that in whose custody, in what condition such seized hairs was kept. In absence of such evidence, the tampering with the same cannot be ruled out, as the hairs of the accused was also collected on 23/6/2003 by the at SCB Medical College Hospital. Moreover, in view of the decision reported in so and so and the Moody's jurisprudence, wherein it is said that microscopic hair comparison alone cannot lead to personal identification. The science of comparison of hair has not yet reached perfection like science of comparison of fingerprints, where the scientific officer posted in the forensic science laboratory had not carried out all the tests meticulously, that is, did not, Roman 1, measure the diameters of the shafts of the hair or their length, Roman 2, take impression of the cuticles of the hairs, Roman 3, note the shapes, appearance, and colors of the hairs, or directions of the pointing out of the hairs, it would be unsafe to rely upon his report. In the present case, the chemical examination report marked as Exhibit 8 indicates that the hair marked by Exhibit D which was bracket later, which was stated to be collected from the belly and right palm of the deceased by scientific officer, tallied with the hair of hair by Exhibit N, bracket hair of the appellant collected by the medical officer, FMT, SCB Medical College, Cuttack, medical education. Tallied with the hair, but did not tally with the hair marked by Exhibit M. Exhibit M bracket cubic hair of the appellant with respect to their morphological and microscopic features. In view of the decisions are cited above, and since there is no evidence of sealing the hairs after it was collected by the scientific officer and handed over to the investigating officer, bracket PW14, and since there is no other clinching evidence on report, and the law requires that each circumstance should be firmly established by adducing cogent evidence, and the circumstances cannot be explained under any other hypothesis, and taken together must form a complete chain. And in this case in hand, it is difficult to hold that the prosecution has established the chain of circumstances clearly with cogent evidence which point to the guilt of the accused. Hypothetical accusation. It appears from the evidence that the main gate of the house in question was locked, and the key was available with the deceased was sleeping on the rooftop. And in order to access the rooftop, the other path could have been used, might have been used by the person who committed the crime. However, The evidence on record that the bloodsstains were found in the staircase out of Milna railing. It creates doubt as to if any outsider after committing the crime would enter into the house, because there was every chance of being caught or identified by the family members of the deceased. And this suspicious feature has not been explained by the prosecution. In view of the foregoing discussions, we are of the view that the conviction of the appellant under section 302 of the Indian Penal Code cannot be sustained in the eye of law. In the result, the appeal is allowed. The appellant is acquitted of the charge. Is he in custody or he has been let out?
Let out.
The appellant who has been released, appellant seems to have has been released on bail by order of this court dated so on. 9/12/2013. His bail bonds and security bonds exonerated from the liability of the bail bonds, and the security bonds stands cancelled. Put a note of appreciation on the Court of the Line Council for Mr. Mohanty and Mr. Mishra.
One prayer, my lord.
Yes.
My name may be correctly.
They named us. Mr. Mohanty got named that excellent. Is it SMBIT?
Agya.
BIT MOH. All right.
To mention, my lord, your lordship directed to supply deposition copy of the list.
In which matter?
CRL 976/20.
Give it.
Pardon me to make a mention. CRL matter for fresh admission.
My lord, I will excuse. I'm from Dhenkanal.
My lord, CRLA 569 of 2022. It is a post-conviction matter, my lords. The petitioner, appellant is a oral cancer patient, my lords. He was released on interim bail on various occasions. He has duly surrendered and filed an IA for bail, my lords. This is the criminal appeal. The lawsuit was directed to list this matter on 9th January with commencing.
What purpose?
The for the status of the custody period of the appellant.
Bail.
No, my lord, criminal appeal. He is in
Criminal appeal.
convicted under section 20B 2C of NDPS Act.
For bail, you want?
Yes, my lord.
Fine.
My lord, one appeal bail matter.
No appeal. Well, about 20 co-accused persons have been
Give it.
Lordship, two appeals arising out of one common judgment, Lordship.
For
For
bail.
hearing.
Or for admission, what?
For hearing, Lordship.
Hearing?
Yes.
What is the year of the?
20 years he has been convicted for 20 years, Lordship.
What is the year of?
Year 2018, Lordship.
2018, why it will be listed? There are old appeals. You can file your bail application, matter is different, but 2018 appeals, 2007,
Bail application is pending, Lordship.
Huh?
Bail application is also pending.
Bail application that can come. You have mentioned that IA number for
No,
bail.
Lordship, I am mentioning and
Mention it and file it.
yes, Lordship. Great.
Tied up bail matter, man. Do it. Obliged.
Yes, Mr. Mishra.
No, not for the mention.
Pardon to mention, my lord. My lord, may I mention criminal appeal number 715 of 2018? My lord, in this matter, the petitioner is already undergone more than 6 years of incarceration. And my lord, the Honorable Supreme Court, by this order dated 13 December 2023, directed this Honorable Court to dispose of the regular bail application within 6 weeks. And my lord, these 6 weeks has already passed, but this matter is not listed yet.
Please tell the number once again, that criminal appeal number.
715 of 2018, my lord.
From Supreme Court on order as she list kar do next week. It will be listed next week, madam. It will to be checked whether any such order is there, and if it is available, it will be listed next week.
My lord,
Oblige, my lord.
my lord, I'm not Dhenkanal VC, my lord.
Yes.
Bail application number 10967.
Please tell once again.
Bail application number 10967, my lord. So this was
of which year?
Sir, 2023. It was being heard. Part had, my lord, it was posted to last 12/1. It was supposed to be posted to today, my lord. But it has not been listed.
See, the problem is that election petition argument is going on. So less number of cases are being listed for that reason. So
Any day,
we'll see that. We'll see that.
oblige, my lord.
My lord, may I be pardoned, my lord?
Patnaik?
My lord, I am at item number 2.
Yes.
Can it be taken up next week subject to lordship's convenience?
Okay, okay. Next Friday you want?
Next Friday.
Mr. Jagannath Patnaik, land senior advocate, appearing to virtual submits that the matter may be taken up next week. Put up this matter on. Acha, Mr. Patnaik, next Friday is a holiday, 26th
Thursday.
So it can come only on 2nd February.
All right, my lord.
Okay, 2nd February.
My lord, can it be in the supplementary list?
Yes, yes, come in supplementary. Yes.
Pardon to mention, my lord. My lord, may I mention JCRLA number 109 of 2022. My lord, the petitioner has already undergone more than 8 years out of 10 years of imprisonment. My lord, I earlier mentioned this matter, but it is still not listed.
Noted down, it will be listed next week. Yes.
Oblige, my lord.
Application item number Jagannath Patnaik Utana 2. Acha, 2nd February. All right.
Supplementary list, item number 30.
Please. My lord. Mic on ही नहीं की? My lord. Before I placing my lord, my senior has extensively argued that we have not pleaded this, we have not pleaded this, we have not pleaded this. And when we yesterday wanted to clarify, again they started to disturb. I request my senior not to disturb. They will get a chance to reply, so they can reply whatever they want to reply. My senior yesterday, my lord, yesterday repeatedly said, Lordship, that amendment could have been done, amendment has not been done. My lord, your Lordship, kindly see this judgment. In an election petition, my lord, amendment cannot be allowed. 1987 supplement, SCC, page 93. Dharti Pakad Madanlal Agarwal versus Rajiv Gandhi. I flag mark, my lord, your Lordship may state, take page 120. There are number of judgments. I will not bother, my lord. Only one judgment I will place. Page 120, my lord. Yes, sir.
Top, my lord. Para 31 ରୁ start ହେଇଛି top ସେଇ page ରେ ଯୋଉଠି flag mark କରିଛି 120. It must be borne in mind that the election petition was presented to the Register of the High Court at Lucknow bench on the last day of limitation prescribed for filing election petition. The appellant could not raise any ground of challenge after the expiry of limitation. Order 6 Rule 17 no doubt permits amendment of an election petition, but the same is subject to provision of the Act. Section 81 prescribes a period of 45 days from the date of the election for presenting election petition calling in question the election of a written candidate. After the expiry of the period, no election petition is maintainable in the High Court or this court has no jurisdiction to extend the period of limitation. An order of amendment permitting a new ground to be raised beyond the time specified in Section 81 would amount to contravention of those provisions and beyond the ambit of Section 81 of the Act. It necessarily follows that a new ground cannot be raised or inserted in an election petition by way of amendment after the expiry of period of limitation. The amendment claimed by the appellant are not in the nature, then the facts they have quoted, Milord. So, Milord, to present of election petition, 45 days is prescribed. After 45, no amendment can be allowed. I can make amendment within 45 days from the date of declaration of the result.
This position still holds.
Yes, my lord. Your lordship, the another judgment, it is in 2001 8 SCC 233. 2001 8 SCC 233 Hari Shankar Jain versus Sonia Gandhi.
Which paragraph?
Para 23, my lord. I have flag mark at page 251. Section 83(1)(a) of RPA 1951 mandates that an election petition shall contain a concise statement of material facts on which the petitioner relies. By a series of decisions of this court, it is well settled that the material facts required to be stated are those facts which can be considered as material supporting the allegations made. In other words, there must be such facts as would afford a basis for the allegation made in the petition and would constitute the cause of action as understood in the Code of Civil Procedure 1908. The expression cause of action has been compendiously defined to mean very fact which would be necessary for the plaintiff to prove if traversed in order to support his right to the judgment of court. Omission of a single matter of fact leads to an incomplete cause of action and the statement of claim becomes bad. The function of the party is to present as full a picture of the cause of action with such further information in detail as to make the opposite party understand the case he will have to meet. In so and so, merely quoting the words of section like chanting of a mantra does not amount to stating material facts. Material facts would include positive statement of the. This judgment was cited also by my senior also, my lord. Material facts would include positive statement of facts, so as also positive averment of a negative fact, if necessary. In so and so, this court has held on a conspicuous of a series of decisions of this court that material facts are such preliminary facts which must be proved at the trial by party to establish existence of a cause of action. Failure to plead material fact is fatal to election petition and no amendment of pleading is permissible. My lord, this judgment was passed under in application under Order 7, Rule 11. In our case, that stage has gone. And Honorable Apex Court categorically said no amendment can be allowed. This was not a case after trial, my lord. This was a case under Order 7, Rule 11. Even then, Supreme Court said if material facts are not there, there is no cause of action. Order 7, Rule 11 has to be allowed. Here, that stage has gone, upheld by the Supreme Court.
Now, if the material facts are missing, as
Yes,
you
my lord.
said,
I'll come to that. I am aware of that, my lord. That's why I am aware. Suppose I have not pleaded something, but my lord, respondent in examination in chief has explained certain things. He made a certain admissions. I cross-examined him as he made a statement in the examination in chief. I cross-examined him and he admitted, yes, it is a typographical error or clerical error, or my advocates will say. So they could have simply said exhibit so and so not pleaded beyond pleading, but rather they said exhibit 17 is so and so, details in exhibit 17 is this, but in my affidavit I have correctly disclosed. So I confronted in both documents that this is false.
Again, I'm just asking for that. Suppose anything which is not pleaded.
Yes, Lord.
So can you put in a civil case? Can you
Yes,
put
Lord.
such a question on that?
Yes, my lord. My lords may. This is SLP civil number
Because
double.
there is no pleading, so obviously there will be nothing in the written statement.
Yes.
Okay.
Yes.
And there would
But
be
in my evidence affidavit also not there.
not there.
Only I exhibited documents.
Now, in such a situation when nothing is there,
He explains, my lord. He explains regarding those exhibits.
because if the question
ନାଇଁ ଚିଫ୍ ରେ ଆଜ୍ଞା କହିଲେ ମୁଁ କ୍ୱେଶ୍ଚନ କଲି ଯେହେତୁ ସେ ଚିଫ୍ ରେ କହିଛନ୍ତି କ୍ରସ୍ ଏକ୍ସାମିନ ସେ ଚିଫ୍ ରେ ଆଜ୍ଞା ମୁଁ ଦେଖେଇଦେବି ଆଜ୍ଞା ସେଟା ସେ ଚିଫ୍ ରେ ଏକ୍ସପ୍ଲେନ କଲେ ସେ ଡକୁମେଣ୍ଟ କୁ କହିଲେ ଏ ଯୋଉ ଅଛି ମୁଁ ଏକଦମ କରେକ୍ଟଲି ଡିକ୍ଲେୟାର କରିଛି
ଏଟା ନଥିବା ସତ୍ତ୍ୱେ ମଧ୍ୟ ସେ
ଚିଫ୍ ରେ ଏକ୍ସପ୍ଲେନ କଲେ ଆଜ୍ଞା The Lordship kindly see this judgment.
Pleading করছো কোটা material pleading ହେଇନି
Your Lordship may straight come to page 17, my lord. SLP civil number 6614 of 2023, Bhim Rao, Basant Rao, Pati, K. Madan Mohan Rao and other. This is an election case, my lord. Your Lordship may page 17, para 22. It has been held by this court. They have quoted, my lord, order 12, rule 6 in para 21 and a judgment. Then it has been held by this court that the expression otherwise mentioned in sub-rule 1 of rule 6 of order 12 CPC is not confined to pleading, but also includes documents filed along with the complaint or main pleading or other materials subsequently brought on record, which are admitted by the other party. In other words, the matter of record that is not denied and contained facts that can lead the court to draw a decree is sufficient for the court to do so, and by its judgment direct decree of the suit, in this case petition wholly or partly.
This word otherwise has been interpreted.
Yes, my lord. I am giving another judgment of Honorable Apex Court, my lord. Another judgment, my lord, in civil appeal number 3048 of 2010, the lordship may straight come to para 49, my lord. 49. 3048 of 2010.
Citation is there, Mr.
Citation hochi Manu oblique
SCC reference ଅଛି.
हाँ SCC ର ବି ଅଛି ମାନେ ପାରା ମ୍ୟାଚ୍ ନ କରିପାରେ ତ SCC ରୁ ସେଇ ପାଇଁ
2010 just
4 SCC 753
Karam Kapahi.
Karam Kapai and others versus Lal Chand Public Charitable Trust.
Lal Chand Public reported in 2010 volume 4 SCC 753. Which paragraph?
Paragraph not 49. SCC रा पारा मैच न करि पारे
जे जणा पड़
para 49
एटी मार्क करिछि
at page 9 मिलो. If the provision of order 12 rule 1 is compared with order 12 rule 1 says on pleading. If the provision of order 1 rule 1 is compared with order 12 rule 6, it becomes clear that the provision of order 12 rule 6 is wider, in as much as the provision of order 12 rule 1 is limited to admission by pleading or otherwise in writing. But in order 12 rule 6, the expression or otherwise is much wider in view of the words used therein, namely admission of fact either in pleading or otherwise, whether orally and writing. Even orally admission hale bhi habo. Then your lordship may turn to para 56. Say page last. Order 12 rule 6 of the code has been very lucidly discussed and certainly interpreted in a division bench judgment of Madhya Pradesh High Court. In case of Shikhar Chand and others versus Mast Bai and others, reported in so and so. In the concurring judgment explained the aforesaid rule, if we may say so, very authoritatively at page 79 of the report, His Lordship's head, I will only add a few words of my own. Rule 6 of Order 12 of the Code corresponds to Rule 5 of Order 32 of the Supreme Court rules, now Rule 3 of Order 27, and is almost identically worded. See, so the Supreme Court rule came up for consideration in so and so. In that case, a suit was filed for ejectment, mess the profit, and damages on the ground of breach of covenant against subletting. Lessee solicitors wrote to the plaintiff's solicitor in which fact of breach of covenant was admitted and a case was sought to be made out for relief against forfeiture. This letter was used as an admission under Rule 5 and there was no substance in the plea of relief against forfeiture. The suit was decreed for ejectment under the rule. Sergeant J rejected the argument that the rule is confined to admission made in pleadings or under Rule 124 in the same order and said the rule applies wherever there is a clear admission of facts and in face of which it is impossible for party making it to succeed. Rule 6 of our order 12, in my opinion, must bear the same construction as was put upon the corresponding English rule by Sergeant J. The words either on the pleadings or otherwise in Rule 6 enable us not only to see admission made in pleadings or under Rule 124 of the same order, but also admissions made elsewhere during trial.
You mean to say that this explanation, whatever has been given by the
they explain in their examination in chief. Then I confronted both the documents. He admitted, yes, it is a typographical error. So now your lordship is to decide whether the declaration made in Exhibit 43 is as per the mandate of the RP Act or not.
So you mean to say that in such a situation, absence of pleading in the election petition not be a bar in taking the same?
But my case is, my lord, I have pleaded.
Oh, it's all right.
Yes.
Their case is that you have.
Their case, I have not pleaded. Now, my lords, yesterday we were pressing on issue number 17 and 21 regarding these criminal cases. In paragraph 7C, my lord, I have specifically pleaded FIR number 136/2012 dated 24/9/2012 in Balianta police station, Cuttack. The respondent and bench.
Yesterday, Mr. Kanung.
Yes.
Said. So if anything is left out, Mr. Kanung also said that if
left out, my lord,
just don't repeat it.
ମୁଁ ଖାଲି ସେ pleading ଗୁରା ଦେଖିବା ପାଇଁ ଆପଣଙ୍କୁ ଏଇଟା ଦେଖଉଛି.
Pleading and the cross that we have crossed him on this aspect.
Mr. Kanung, what I say that if the important thing is there, you may point, otherwise make in that note. Suppose this case, pleading is this, paragraph number, this top line from this one. Evidence is evidence affidavit.
Chief रे या कहले cross रे आगे.
Cross and respondent in the chief and cross. A type of kardele. These are very easy to find it out.
Yes,
it should not, because the time constraint.
I have to close today because from Monday I will be not here.
That is why I am telling you that.
Your lordship, only one document I will place, my lord. The important document, my lord, he stated that in view of your lordship, kindly see Exhibit 43.
No, yesterday also we saw.
It's a newspaper katha mu khali dekhai debi apan.
There are three type of explanation he
has given, my lord.
One is clerical error or
typographical, my advocates will say.
A tinta explanation.
I'll just request my lords to kindly see Exhibit 43. Page 9, my lord.
Speed record. Yes, 43. Page 9.
Page 9, my lord.
7 it आता. 9.
Note. Top.
First note na second what details of immovable process.
ऊपर था ऊपर first note. D line पर जो note. Details should be entered clearly and legibly in bold letters. Details should be given separately for each case under different columns against each item. Details should be given in reverse chronological order. The latest case to be mentioned first and backwards in the order of dates for the other cases. Additional sheet may be added if required. Type is important, my lord. Candidate is responsible for supplying all information in compliance of Honorable Supreme Court judgment in WPC number. This is Constitution Bench judgment. When we pleaded, my lord, that he has suppressed in his affidavit, they came with a case. No, I have correctly disclosed. And they exhibited, my lord, 3 documents. Exhibit B by 1, C by 1, D by 1. Those new. And I have correctly complied the direction of Honorable Apex Court. My lords may kindly see Exhibit B by 1. Your lordship got it, madam?
No, B by 1 is that
newspaper. This was, my lord, after scrutiny before election. So it's not that in affidavit he has given false declaration. In newspaper also he gave a false declaration. Whereas they say that we have correctly published as per direction of the Supreme Court. And these documents were to say that they have correctly, they exhibited these. We have not pleaded, my lord. We have not raised the objection regarding these publications. But they pleaded and they exhibited these documents. So, Lordship, kindly see serial number 1. He has declared that the said case is registered under section 143, 294, 431, 149 IPC and 7/4 of PDPP Act. If your lordship looks to the exhibit 17, my lord, the said FIR has been registered under section 147, 148. टिके आज्ञा खाली से FIR exhibit 17. ମୁଁ ନୋଟ ରେ ଚାର୍ଟ କରି ଡିଟେଲ ଦେଇଦେବି ଖାଲି ଆପଣଙ୍କୁ ଦେଖେଇ ଦઉં।
ଆଚ୍ଛା ନାଇଁ ଏଇଟା ଏଇ ଯୋଉ କେସଟା
ଆଜ୍ଞା
ସେଟା ସେଇ ସ୍ଟେଜ ରେ ଥିଲା ଇନଭେଷ୍ଟିଗେସନ ସ୍ଟେଜ ରେ ନା
ନାଇଁ ସେଇ FIR ରେଜିଷ୍ଟର୍ଡ ହେଇଛି କଗ୍ନିଜେନ୍ସ ହେଇଛି ସମନ ହେଇଛି ସେଇ ସ୍ଟେଜ ରେ
ସେଇ ଯେ
ନାଇଁ ଚାର୍ଜ ଫ୍ରେମ ରେ
କଟି ଯାଇଥିବ ଚାର୍ଜ ସିଟ୍ ରେ
ନାଇଁ
କାରଣ ଅଫେନ୍ସ ସବୁ ଗୁଡା
ନାଇଁ ହି ଆଡମିଟେଡ my lord I'll place that evidence also
ମୁଁ ସେଇଥିପାଇଁ କହିଲି ଯୋଉ ଆପଣ କହୁଛନ୍ତି ନା କମ କିଛି
ମୁଁ
ଅଫେନ୍ସ
ସେ ଏଭିଡେନ୍ସ ଟା ବି ଦେଖେଇଦେବି ସେ I'll place his evidence also.
So this is that case. This is Purighat PS case number 149 dated 11/9/2018 and GR is
1722 of 2018.
Here,
my lord, this FIR has been registered under 147, 148.
total number of 11 offences
Yes.
has been mentioned and 12 is also 2 offences under PDPP Act.
Yes, but in the newspaper, my lord, he only added 4 under IPC, 2 PDPP.
These offences were deleted from.
Yes, my lord. It's a false declaration, my lord. These offences are not there.
এটা ওই 1722 যেটা বাহার করছিল
Exhibit 17
newspaper 1722. Okay, yes, he has just mentioned 4 offense
143, 294, 4
the back procedure FIR
431 ମୁଁ ଆଉ ଗୋଟେ କପି ଦେଇ
ନାଇଁ ଠିକ ଅଛି ନାଇଁ 11ଟା ଅଫେନ୍ସ ହଉଛି ଆଇପିସି ର
ଆଜ୍ଞା
ଆଉ 2ଟା
ଦିଟା
ଅଫେନ୍ସ
ହଉଛି
ହଉଛି
PDPP
PDPP ର ହେଲା
ଆଜ୍ଞା
ସେ ଦେଖେଇଛନ୍ତି
ଏଠି ଆଉ ଦେଖେଇଛନ୍ତି 4ଟା IPC ର 2ଟା PDPP ର
newspaper clipping 4 IPC offense and 1 2 3 4 and 2
newspaper
PDPP.
it will be convenient for my lords to compare.
ହଁ ମୁଁ ସେଇଥିପାଇଁ ସେ ଏପଟକୁ ସେପଟକୁ ଯିବାକୁ ପଡୁଛି ହଁ that will
ସେ FIR ଖାଲି ସେଠୁ ଦେଖେଇଦେବେ ଆପଣ ନ୍ୟୁଜପେପର ରୁ କମ୍ପେୟାର
ଠିକ
କରିବେ
ଅଛି newspaper ହଁ ଏଇଟା
ଏଥର ଆଜ୍ଞା ଦେଖେଇଲେ 4ଟା IPC ର ଅଫେନ୍ସ
ଏଗୁଡାକ ସବୁ ନୋଟ କରିଦେବେ ନା
ମୁଁ ନୋଟରେ ଦେଇଦେବି ଆଜ୍ଞା ଆପଣ ଯଦି ନୋଟ କରିବେ ଟିକେ ମୁଁ ନୋଟରେ ଡିଟେଲ ଲେଖିଛି ଡିଟେଲ ଦେଇଦେବି
just a minute. GR
serial number 1 of exhibit B1 C1 D1
172288 ର ହେଲା FIR ହଉଛି
Purighat PS case number 149 dated 11/9/2018
ଏଟା ମାର୍କ ହେଇଛି
ହଁ exhibit 17 ମିଲଟ
exhibit 17 ତା ଦେହରେ ଅଛି 11ଟା IPC offense 2ଟା PDPP
ଆଜ୍ଞା
এটা whereas newspaper clipping এটা ହେଲା exhibit କେତେ ହେଇଛି
newspaper B1 C1 D1 on 3 occasions milord he published not that in one occasion he has given wrong in other occasion he has given correct
B/1 C/1
D/1 C/1 D/1
তিনটা আগের সেই সেম
তিনটা করে সেম
আচ্ছা 4 IPC offense and 2 PDPP offense okay তারপরে
and milord one another thing this FIR was registered on 11/9/2018 but in the affidavit at exhibit 43 he declared this FIR has been registered on 15/9/2018 that is also false declaration your lordship kindly see exhibit 43 page 4 He admit in his cross exam, he explains in his chief. I have correctly mentioned 43 page 4. Column A re first FIR file FIR number 149 dated 15/9/2018. Again, but the FIR is registered on 11/9. The date is also wrong.
Date of registration is wrong.
Exhibit 17 रहला गया 11/9/2018
9008
in exhibit 43 रे 11/9 होची exhibit 17 रे.
Name of this one, so एटी आसले एफआईआर टा बसन एफआईआर टा जोड़ा बाहर करते लगे
exhibit 17 मिला
17 नंबर हाँ एटा रजिस्ट्रेशन है 11 ठीक है
क्या एविडेंस है माननी चाहिए आगे मु
तापरे
देखिए दे. Then your lordship kindly see serial 2 18 GR case 1722
गला अपना
sorry 1723 of 2000 serial 2 मिला
हाँ 2 तक
1723 of 2018. Here, my lord, in the newspaper, he has declared 11 cases under IPC and 2 cases under PDPP. If your lordship looks to the exhibit 18,
that is the FIR.
That is the FIR.
नहीं मु अगेन आपन को ये कहूची जे ए केस गुड़ा को तो जे लेट अस से रजिस्ट्रेशन हेची
अगर नहीं चार्ज ये चार्ज है नहीं आगे
हां
ओनली वन केस चार्ज हेतला जोटा कन्विक्शन आउ चार्ज है
कारण सेते बळे कमी जाए माने
आगे
तो कमी जाई
पारी जाय
कॉग्निजेंस भी कम जाई थाई पारे कि चार्ज भी कम जाई पारे
नहीं सेटा एठी एफआईआर टा होची 4टा सेक्शन है सेठी लिखुचंते 11टा सेक्शन तो कम बढ़िबो केमती कमिबो
ठीक है फायर राइट नेक्स्ट होची 1723 ऑफ 2000 ले
एग्जिबिट 18 मिलो
एग्जिबिट 18 टा होची जेटा होची चारटा ऑफेंस
दिटा पीडीपीपी रे से एठी लिखुचंते 11टा ऑफेंस दिटा पीडीपीपी रे
एटा पूरी घाट पीएस केस नंबर
सेम पूरी घाट पीएस
जीआर टा होची 1723 हां ठीक चलो exhibit 18 FIR indicates 4 IPC
and 2 PDPP. But in the exhibit B1, C1, D1, 11 offenses under IPC. 1723-18
newspaper exhibit C/1 C/1 D/1
11टा सेक्शन है 11टा आईपीसी रे 11टा पीडीपीपी टा ठीक अछि
IPC and 2 PDPP ऑप्शन छोड़ा बोले ऊपर से
आगे it amounts to false declaration. You have violated the order of the constitution bench. Please
माने जानिया
और कहउचंदी मु आंसर दउची मु देबी आगे
हेला बेली जानिया
से ऊपर तळे हिच आगे
ऊपर तळे माने 2 नंबर ऑफेंस गुडा को
1 नंबर रे हबा कथा
1 नंबर गुडा
2 नंबर रे हबा
ठीक है नेक्स्ट
here also my lord date of registration FIR is also false. If your lordship looks to the again that exhibit 43 serial number 2
FIR रो डेट होची एटिका FIR होची 11
11 नो exhibit 43 रे लिखिले 15 नो Page 4 ର serial number 2 ରେ
सेम टाइप रो माने
same mistake मिलो
तापर पळे सुन 3 नंबर टा
3 number Special Judge Bhubalens TR 41 2013
ये नंबर ठीक अछि क्लियर
आज्ञा
41 ऑफ 2013 नंबर ठीक अछि
41 ठीक अछि आज्ञा एई 41 TR रो corresponding VGR number they have not disclosed in their affidavit in form 26
जीआर पे गोटे कॉलम अछि पुरा सेठी
VGR ପାଇଁ ସେଠି ଯେ ଆର corresponding VGR number ଦେଇନା
ସେ जो केते नंबर सेटा एग्जिबिट टा
exhibit 30
30
मिलो 30 ର order sheet 4 पेज तळे FIR टा लागि
तार VGR नंबर होछि
VGR number 34 dated 6/9/2007 Bhubaneswar Vigilance Police Station
हां
they have stated FIR number 34 Kattak Vigilance Police Station
खूब एथर अछि जो 40 केते
43
टा टी
serial number 12 मिलो Say page 4 ର serial 12 FIR number 34 dated 6/9 Vigilance Police Station Kattak there is no mention that FIR number 34 of Vigilance Police Station Bhubaneswar is pending against him this he has suppressed and this he has given a false declaration in this case he is not an accused my lord what he has declared
in this way you just give that
yes my lord
तेरटा का केस रे जहां भूल भाल अछि सब लिखि किन देलो
आज्ञा
यस
सेमिति देखै देबे आज्ञा ना दे
नहीं
देबे
आ दरकार नहीं
आज्ञा
अपन देई देले मु देख दे ये तो जिंस वाला
आज्ञा आज्ञा
नोट डाउन कर दे
आज्ञा
तेरटा सीरियल नंबर अनुଯାयी देई देले
serial number 1 2 3 करी serial number दे दे
serial number
only your lordship kindly see on this context is a examination
ସେଇ ତିନି ପ୍ରକାର explanation ନା ଆଉ କିଛି ନୂଆ
ନା ଏ ବିଷୟରେ ନ୍ୟୁଜ ପେପର ରେ ତାଙ୍କର ଗୋଟିଏ ଏକ୍ସପ୍ଲେନ my advocate will say and the advocate when comes he has not stated anything either in chief so we have not cross he has not stated anything
ଦି ଜଣ advocate को examine करथले ना
ହଁ
he has not stated anything
he meant to say
ସେ କହିଲେ ତାଙ୍କ ଷ୍ଟାଣ୍ଡ ହେଲା
the conducting counsel not
ସେ ଯାହା ମିନ୍ ହଉ ଆଜ୍ଞା ସେ ଏକ୍ସାମ ସେ ଯୋଉ ମିନ୍ ହଉ କଥା ହଉଛି ସେ କହିଲେ my advocate prepared draft of this publication ସେ advocate ନା କହିଛନ୍ତି ତାଙ୍କ କ୍ରସ ରେ conducting counsel को ना ତାଙ୍କ ନା କହିଥିଲେ ଯାହାକୁ ସେ ଏକ୍ସାମିନ କରିଛନ୍ତି he has not stated he stated advocate said only I verified handed over the slip ସେ slip को कौन लिखिକି ଦେଲେ କौन नहीं that was not produced and respondent admits at the time of swearing affidavit in form 26 all documents was available with me ସେ ଯୋଉ PC Act ରେ ଆଜ୍ଞା ଦେଲେ କହିଲେ कि मोर applicable में I have put him a specific question
नहीं गोटे लाइन से कहले कहले आया 13टा केस थिला बोधे एई एबिट
आज्ञा।
अछि 13टा केस थिला मु 13टा केस देखिछि केस संख्या रे किछि उणा करिनी आउ ये तो कोडी जगह
ଆମର ବି केस आଜ୍ଞା ନାହିଁ कि 13 ଟାରୁ ଅଧିକା केस ଅଛି we also admit 13 cases pending
गोटे ऑफेंस कोन एपड हे जेतो कोडी आउ
yes now the question is whether this is permissible question is whether it is not
कारण से विषय रे
to some extent is giving the explanation like this.
Yes, my lord.
जे मु 13टा जाको केस काटिनी सबु देखैची एफआईआर को भी देखैची ये जो
But it is a typographical, clerical, or my advocate. This is explanation. Question is whether this is permissible. Your lordship, kindly see exhibit 43, page 26. Yes, Bhubaneswar case pending. Se koibe Katak re. How a voter will know?
No, that is
Your lordship, kindly page 26. Verification.
20.
Page 26 of exhibit 43. I, the deponent above named, do hereby verify and declare that the contents of this affidavit are true and correct to the best of my knowledge and belief, and no part of it is false, and nothing material has been concealed therefrom. And we have given a judgment, my lord. Once on the oaths, act, and all has been dealt with, even one word in place of BA, MBA was typed. Stand was taken, it was clerical error. High Court set aside election. Supreme Court said this cannot be accepted. And our own High Court, my lord, one khata, one property was left. Two questions were raised in this Jogesh Kumar Singh case, my lord. One, he is not scheduled type, seat is reserved for scheduled type. Two, he has suppressed khata number so-and-so, plot number so-and-so in his affidavit form 26. On the question of he is not scheduled type, High Court negative that. No, he is a scheduled tribe. But on suppression of one khata plot, his election was declared void. And in one case, that Patna High Court judgment, only one criminal case under section 145 was registered, CRPC 145. That was not disclosed. Supreme Court said it is a false declaration. Sorry, Patna High Court said it is a false declaration. So, and if your lordship looks to the exhibit 43 and the declaration made regarding criminal cases, where the Honorable Apex Court, it is, they have to give correct and true declaration regarding at least criminal cases. If your lordship look to the exhibit 43, not a except one or two, either offense wrong, court name wrong, date of FIR wrong, even exhibit for charge frame date he has given false. He has appeared, gone on bail, not that it is not within his knowledge. Your lordship, exhibit 49. Your lordship is asking the date of charge. Your lordship, kindly see exhibit 49. Page 3, my lord. Date of framing of charge 10/4/2015. Your lordship, kindly see exhibit 43, page 7.
चार ଦେଇଛନ୍ତି
29/8/2013 ମୁଁ ଆଜ୍ଞା ଯିବି 29/8/2013 ଅର୍ଡର ସିଟ୍ ଆଣିବାକୁ କହିବା ଏଠି ଅର୍ଡର ନାହିଁ ଏଭଳିଆ କିଛି
କୋର୍ଟ ନା ଗୁଡା ଠିକ ମେନସନ କରିଛି
କୋର୍ଟ ନା ଠିକ ଅଛି କୋର୍ଟ ନା ଠିକ ଅଛି but that FIR number जो corresponding FIR number has given false column 5 ରେ
mandates that the correct date of charge has to be given
जो column 5 ରେ जो ଦେଲେ FIR 34 Cuttack Vigilance Police Station but in fact it was registered by the Bhubaneswar Vigilance Police Station
29/8 ରେ କିଛି ଅର୍ଡର ପାସ୍ ହେଇନି
ନା
କାହିଁକି ମୁଁ କହୁଛି ନା ଗୋଟେ ଚାର୍ଜ କେସ ରେ
चार्ज अल्टर हो जाए
नहीं नहीं
कोई काले
नहीं एक
दिन
तो नहीं ହେଇଥିଲା ଆଜ୍ଞା ଜଜମେଣ୍ଟ ଏଇଟା ଜଜମେଣ୍ଟ ହେଇଥାନ୍ତା
ऑलराइट यस
So, my lord, my humble submission is he has declared false declaration in his affidavit exhibit 43. One more aspect, my lord. He filed 4 nomination papers. Section 33A mandates, along with the nomination paper, he is to file affidavit. Section 33A never mandates that he can file a Xerox copy of the affidavit. Only one original affidavit was filed. 3 were Xerox attested copy. So your lordship is to also consider whether the returning officer rightly accepted his other 3 nomination papers. As required under section 33A and rule 4A, he has not filed the affidavit original.
Because in the 4 sets of nomination paper, the proposer may be different. So even if one is rejected or 3 is rejected,
one can survive.
If that one contains a Xerox copy of the affidavit,
Yes, my lord.
so it would not be. So that is why you submit that original is necessary.
Sir, ଆମେ ଯେତେବେଳେ କୋଉ ବି candidate or nomination when we file, 4ଟା original, sir ବି ନିଶ୍ଚିତ 4 I don't know who has filed this, but it is a downright mistake. 3ଟା Xerox
No, the
କରିବା
reason is that କୌଣସି କଣ ଗୋଟେ mistake ହବ ଯଦି
ହଁ
ଗୋଟେ ତା ଯୋଉ
ସେଇ ପାଇଁ
reject
ତାହେଲେ sir mistake ଥିବ ଗୋଟେ ଧରନ୍ତୁ nomination ରେ କିଛି mistake ଥିବ ଅଲଗା nomination କୁ ଯିବା ବେଳେ ଯୋଉଥିରେ ସବୁ correct ଅଛି Xerox affidavit that cannot be accepted. That is the main thing. The 33A mandate ସେ ସବୁଥିରେ ଗୋଟେ affidavit ଦିଅ ସେଇ affidavit ଟା repeat ହେଇକି ଦିଆହବ Xerox
ତା ଦେହରେ ଆଜ୍ଞା କଣ ନା 4ଟା nomination paper exhibit 39 40 41 42 he admits exhibit 39 one document was shown to the arrow that it was filled up other 3 documents were blank nomination paper were even blank जो nomination ता fill up ହେଇଛି ସେଇଟା ହଉଛି 42 ସାଙ୍ଗରେ Xerox copy affidavit ଦିଆ ହେଇଛି 39 nomination paper they have left some delete kale part 2 and certain columns they have left blank so with
Mr. Another thing just please clarify. Suppose he filed the number ଗୁଡାକୁ ବି ଦିଆ ହଉଛି ନା ସବୁଥିରେ 1 2 3 4 ହେଇକି ନେଲା
ଆଜ୍ଞା
suppose ସେ 1 ଟାକୁ verify କରିଲେ ଦେଖିଲେ everything is okay
ଆଜ୍ଞା
is it necessary to go to 2 3 4 again?
yes my lord he is to check all nomination paper and I have specifically your lordship has put a question he said first I verified then second then third then fourth he himself has said
ସିଏ ତ କରିଛି ସିଏ
ଆଜ୍ଞା
କେସ୍ ରେ କରିଛି ସେଠି ଯଦି ଗୋଟେ ନୋମିନେସନ ପେପର ଯୋଉଟା ବି ଠିକ ହେଲେ ଚଳିବ
ଆଜ୍ଞା
ହେଲା
ଆଜ୍ଞା
ସେ ଅନ୍ୟ ଗୁଡାକରେ ଭୁଲ ଥିଲେ ମଧ୍ୟ ଇଗ୍ନୋର କରିକିନି
ଆଜ୍ଞା
ତାକୁ ଆକ୍ସେପ୍ଟ କରି ତାକୁ ପରମିଶନ ଦିଆଯାଇ ପାରିବ
ଆଜ୍ଞା
ଟୁ କଣ୍ଟେଷ୍ଟ ଦି ଇଲେକ୍ସନ
ଆଜ୍ଞା
ସପୋଜ ପ୍ରଥମଟା ଯୋଉଟା ସିଏ ହେଇଛି ସେଇଟା ଠିକ ଆସିଲା
ଆଜ୍ଞା
ତାହେଲେ ଆଉ କଣ ଜଷ୍ଟିଫିକେସନ ଅଛି
ଆଜ୍ଞା ସେ ପୁରା 4ଟାକର ଦେବ କି ମୁଁ କୋଉ କୋଉ ନୋମିନେସନ ତାର ଆକ୍ସେପ୍ଟ କଲି ଭ୍ୟାଲିଡ ବୋଲିକି
ସବୁ ପୁରା 4ଟା ଯାକ accepted
4ଟାକରୁ ସେ ଦେବ ଭ୍ୟାଲିଡ ବୋଲି ସେ ପାଇଁ he is to examine all 4 nomination papers ସେ 4ଟାକ accept ବୋଲିକି notify କରିବ
ଏତିକି ସେଟଟା ଦେଲେ ଏଇଟା ଭେରିଫାଏ ଅଛି
and he is just to give a acknowledgement that at the time of scrutiny it's this serial number 2 is valid serial number 3 is valid serial number 4 is to give a acknowledgement
then it's over
so he is to and RO himself has to verify if your lordship looks to the RO evidence he said I only put the serial number and the date I have not verified my officer the HBRO mandates me lord the RO is to personally verify those documents he should not allow anybody to touch either RO or ARO here ARO was not there RO himself is to be he said I have only put my team who was the team officers I don't know now my lord
Lordships, now we are coming.
criminal ये विषय
ମୁଁ note ଦେଇଦେବି
Note ରେ ଆମେ
ମୁଁ
ଦେଇଦେବୁ।
detail evidence ଇଏ
ଯେମିତି ଲେଖି ଦଉଛନ୍ତି sir, ଆଗେ ଲେଖିବୁ pleadings, ଆମର examination in chief,
ନାଇଁ pleadings, my pleading, their pleading, my examination in chief, their examination in chief, then exhibit 43 ରେ କଣ ଲେଖିଲେ ସେ chief ରେ କଣ କହିଲେ
ଇସ୍ୟୁରେ relevant
ସବୁ ଯାକ ଇସ୍ୟୁ ଏକା ସାଙ୍ଗରେ କହିଲେ
ଏକା ସାଙ୍ଗରେ
ସେ ଯୋଉ କ୍ରିମିନାଲ ପାର୍ଟ ର ଅଲ୍ ଇସ୍ୟୁ ଟୁଗେଦର
together. Sir, ଏଟା ହେଲା ଆମର issues 22, 23, 24, 25, 26 and 27. 22, 23,
ମୁଁ କାଲି ବି କହିଥିଲି ଆପଣମାନଙ୍କୁ ଯେ ଏଇ ଯୋଉ ଇସ୍ୟୁ ଗୁଡାକ ଆପଣ ମାନେ ଇଏ କରିଦଉଛନ୍ତି both sides should answer in ତାଙ୍କର ଇଏରେ ରେସ୍ପେକ୍ଟିଭ ହେଲେ ଇଜି ହବ
23, 24, 25, 26.
ଏଗୁଡା ହଉଛି ସବୁ ସେଇ କ୍ରିମିନାଲ କେସ୍
ନାଇଁ
ନାଇଁ ଏଟା civil.
asset and movables
just a minute.
And 27. ଛଅଟା
ଇସ୍ୟୁ ନମ୍ବର ଗୁଡା ଆଉଥରେ ମତେ କୁହନ୍ତୁ
22,
yeah
23, 24, 25, 26 ଆଉ 27. Sir, as we have already pointed out, the form is formulated under powers under Rule 4A, this form 46, 26, which mandates to give certain information. These will all be treated as regulations and rules under Article 324. Now, the form mandates a particular manner in which to give information regarding your assets. So, for example, say election petition रे हमें 7D रे हमें ये कॉलू in column 7A note 1 of the prescribed form
7D टा करके
7D
केते पेज का
sir 7D हला page
page 13
page 13 sir we have pleaded column 7A note 1 of the prescribed form of form 26 requires assets in joint name indicating the extent of joint ownership will also have to be given. Into respondent affidavit re lekhi dele has mentioned a joint account number, though has mentioned about the account number 137701359 joint account in the Federal Bank Limited, BK Road, Cuttack, and about account number 10861744745 joint account in SBI main branch, Badambadi, Cuttack, but has not disclosed the name and other details of the joint account holder of the above said bank accounts and has not indicated about the extent of ownership in the said bank accounts. He has not disclosed that he has in whose the joint other account holders name he has not disclosed. Neither has he disclosed what is the percentage of his jointness. 30%, 40%, 50%, 60% he has not disclosed. This is what is mandated under the form. Note re dekhibe
exhibit 43 page 9
exhibit 43 page 9
43 9
details of movable assets kemti describe hoga. Note 1 assets in joint name indicating the extent of joint ownership will also have to be given. Then in case of deposit stroke investments, the details including serial number, amount, date of deposit, the scheme, name of the bank stroke institution and branch are to be given. Then 3 value of bond share debentures as per current market value in stock exchange in respect of listed companies and as per books in case of non-listed company should be given. Dependent means parents, sons, daughters. Details including amount is to be given separately in respect of each investment. Totally the manner in which he is to disclose his movable assets. Next page your lordships will see
joint year कोटा देखै चंदी आपन को
jointly देखै चंती पेज 10 देखिए सर।
Page 10. हाँ,
2
Serial 2.
फेडरल बैंक लिमिटेड 2
हाँ,
टा
2 टा, हाँ,
विदिन ब्रैकेट जॉइंट अकाउंट
joint account,
Account
हाँ,
number joint.
अकाउंट नंबर पर जॉइंट अकाउंट एज ऑन 31/3/2019
हाँ,
अमाउंट रहिला। देन
8. Serial 3.
सीरियल 3
ଏଇଠି ଇଏ ଦେଖେଇଥାନ୍ତେ ଆପଣ କହୁଛନ୍ତି କାହାର କେତେ ଇଏଟା
Extent of ownership. ସେ ନିଜର
Extent-
ଲେଖିଥାନ୍ତେ ଆର କଲମ they have taken a stand, it is either or survivor. ଯଦି either survivor ସେଇଟା ସେ ଲେଖିଥାନ୍ତେ, and then spouse next column, spouse column they have not mentioned that this is the joint account.
ହଁ, ସେଠି ବି ମେନସନ
ସେଠି
କରିବା
ବି
କଥା
mention କରିଥାନ୍ତେ।
ସେଠି ବି
because it's
mention
a
କଲା ତାଙ୍କର ଏଭିଡେନ୍ସ ରେ କହୁଛନ୍ତି it is a joint account with my spouse.
ହଁ,
Then it should have also been mentioned in the
Right.
spouse's account. Otherwise, joint ownership kaha sangre achi he has not disclosed. And what is the extent of jointness?
Hmm.
ତାପରେ sir ଦେଖିବେ
Serial
serial 3
ସେଟା 3 ହେଇଛି, ଏଟା 4 ଦି ଥର।
ଏଟା 3 ଦି ଥର ହେଇଛି। SBI main branch ଟା ଦେଖି SBI main branch Chandni Chowk Cuttack account number such and such joint account
Hmm.
as on 31/3/2019 gala. Then
next is serial
next sir ଆସିବେ
share 3. next page.
page 11
Hmm.
Roman 3 details of investment in bonds, debentures, shares and units in companies, mutual funds and others and amounts and the amount.
Hmm.
Share equity in Metro Builders Private Limited 10,55,000. Share equity in City Trade A hela 12,50,000. Share equity in Metro Garden Estate Private Limited 50,000. Share equity in Metro Supermarket 40,000. Share equity in Metro Guards ये लक्षे 26,000. Then his wife share equity in ASF Construction Private Limited 40. Share equity in City Trade Arcade 5,81,000. Share equity in Metro Garden Estate Private Limited 25,000.
Declared whether it is investment or it is book value.
My lords, they have not declared whether this is their investment or book value.
Hmm.
And he says he knows that book value is different from
Hmm.
the investment value.
Hmm.
And there is a particular, my lords, in accountancy, there is a particular manner in which the book value is calculated. We'll give that calculation. Upon details of investment in NSS, postal saving, insurance policies and investment. देखिए LIC number 5 are dated 28/11/9 yearly 2,53,600 surrender value. He does not declare his investment.
And yearly cannot be surrender value.
And yearly कौन आ गया surrender value टा yearly होगा. He does not declare because he has to declare his investment.
How much he has deposited?
How much he has deposited. आ गया 25 लाख टका धरंतु हैला LIC maturity value टा ମୁଁ ବର୍ଷକୁ ଧରନ୍ତୁ ଦେଲି 50,000 premium. So he has to mention, if your lordship again sees the details, in case of deposit, investment, the details including my lords note re, in case of deposit stroke investment, the details including serial number, amount, date of deposit, the scheme, name of the bank, institution and branch are to be given. Then 5 details including amount is to be given in separate for each investment. तो आगे धरंतु 15 लाख टका हला मोर मैच्योरिटी वैल्यू. सरेंडर वैल्यू इज मैच्योरिटी वैल्यू. तो सरेंडर वैल्यू 15 लाख टका हला आजि जाई मु 5 लाख टका इन्वेस्ट करछि. एई डेट रे पैसा देछि. एई डेट रे पैसा देछि एते टका पर डेट देछि. That he has to all disclose.
Surrender value is not required to be given.
And surrender value is not required to be given. He has given.
He has to give what is investment.
He has just bungled up the entire thing. Yearly 2,50,600 surrender value. ता माने कौन? आज्ञा जहाँ से डिक्लेयर करिवे गोटा कॉमन वोटर तो बुझी परिवे एई जिंसो से मीन करचंती. से कहउचंती yearly ଏତେ ଟଙ୍କା 2,53,600 ତାପରେ ତଳେ ଲେଖୁଛନ୍ତି surrender value ସେ 2,53,000 ଦଉଛନ୍ତି as premium ନା ସେଟା ତା surrender value nothing he's just written surrender value and surrender
Yearly.
value is not supposed to
That
give
too yearly.
and that too yearly so that he has not written anything specifically nor has he disclosed the date of investment. Our cross examination is said that it has been
Credited to my account.
this surrender value mu
Matured
mention
date.
kali kind of say matured hei jaichi mo account ku it has been credited then again he says I don't know anything about this maturity value whether it has been credited or not. So he has given a false and misleading statement. The wife tankara spouse
this note number 2 would be applicable in this case.
2 and 5.
2 and 5
Details including amount is to be given separately in respect of each investment.
No, I would you note 2 re rochi na.
Note 2 re bhi debe. In case of deposit invest the detail
এটা investment type ro hala tha.
Investment.
Investment.
Serial number, amount, date of deposit, the scheme name of the bank, institution and branch are to be given.
A scheme ta bhi deina thi ra to mane karo जीवन आनंद की जीवनम को सेटा भी देना थी
ଆଉ column 4 ଟା ବି ଦେଖିବେ sir
LIC ଟା ଆପଣ ଚଲେଇଛନ୍ତି ତ ମୁଁ ସେ LIC
ନା LIC ଆଗରେ sir LIC ଆଗରେ ସେ form ରେ include ହେଇଛି details of investment in NSS postal saving insurance policies and investment in any financial instruments in post office or insurance company and the amount.
এটা insurance company heading রে জানা
Insurance policy রে details of investment. তো investment से कोठी देखो ना से directly surrender value टा कि कौन से देखे जदी no one knows. Yearly कौन से 2,53,000 पाउचंदी ना कौन से mean करचंदी no one knows. Then his spouse also he writes like LIC number ete dated 28/11/96 yearly 1,70,155 again in bracket he writes surrender value. It doesn't show the amount of investment. Then again my lords eta hala LIC policy number ete dated ete half yearly that has been left blank. Rupees ta siada lekha sorry 6,49,949 surrender value.
Half yearly surrender value कौन?
Half yearly surrender value टा कौन होगा ये?
Half yearly maybe that premium टा half yearly दबाको पड़िबो.
हाँ.
आउ फाइनल तारो surrender value बोधे एतिक ऐसे ही सेंस रे बोधे लेक्चर.
मतलब
surrender माने जोड़ा maturity जो amount टा.
Maturity value he is not supposed to declare his investment value.
Investment.
Can sir dharantu the voter wants to show that I am a very rich person ମୁଁ corruption କରିବି नहीं 5 कोटी टंकार insurance policy नहीं गला मोर investment गोटा premium sorry ମୁଁ गोटा premium देई देली ମୁଁ मोर देखै देली investment that LIC policy is 5 crores so the voter is misled. And be it as it may, my lords, he has to give correct information as per the format given by in Form 26, which is rule under
Rule 4A.
Rule 4A under 324. These regulations are being framed under 324 of the Constitution. Rule 4A answer, I am to give the investment as sought for. ମୁଁ ମୋ ମନ ଇଚ୍ଛା information ଦେଇଦେଲେ that nomination is bound to be rejected.
Amount deposited, date of deposit, को scheme रे deposit कलो, को bank रे बा institution, यार detail टा दो. जोटा कि से अपन कहउछंदी से दे दीचंदी book value ना कौन
surrender value.
ना এটা surrender value.
Surrender.
It is correct करो that cross से कहउछि मो account credit है कि आर कहउछि मो जान नहीं.
बेले बेले से माने in one place he says एगुरा सब मोर account को credit हे जाईछि जदी credit हे जाईछि तो then there was no LIC policy जदी credit हे नहीं he says जे मु again he says it has not been credited ताले तो he has not declared his investment nor the insurance means the
date of deposit,
date of
policy name.
details of investment.
एटा yearly माने जो LIC policy yearly माने yearly आपन को premium दबा को पड़ी
Premium
premium है
हाँ
we do not know man
हाँ नहीं
तापरे लिखि दउचंदी surrender value.
Surrender.
So this creates total gives false information to the voters and misleading. The voter will not be able to know whether it is like your lordship is not able to play. Apun jodi पढ़ी कि निजे जानी पारथांते yes this is the thing that he is meaning to say, then I understand. Voter will not be able to know what he is trying to say. So that is misleading and false information is given. से कठोर केस रह गया से कितने परसेंटेज तार अच्छी पार्टनरशिप फर्म रे he did not disclose. That was one of the grounds for
what the questions have been put about that book value से कौन कहउछन
book value आज्ञा से कहउछंती book
तब पचराई जी
आज्ञा सब पचराई
नहीं से माने व्हाट इज रिप्लाई हमने माने पचरा पे तो
दउछे
जे तुमको एटा इन मेंशन करियार थिला तमे बुक वैल्यू मेंशन कलो बुक वैल्यू माने होची या उनकी पचराई जी
यस यस
सर सेटा ऊपर कॉलम डिटेल्स ऑफ इन्वेस्टमेंट इन बॉन्ड्स कॉलम 3 सेटा आगे कहउछु सर
The Lordship kindly see cross-examination at page 60. RW1. এটা তো তারই knowledge না আর কি
RW1.
This is again within his special knowledge.
हाँ कितने पेज कौन तो?
Page 68.
68.
Para 89. Regarding book value, my lord. Page 65, para 87. No. Yes, sir. Page 66, para 88. Regarding the share. Page 66, para 88. It is a fact that the amount reflected in serial number 1, 2, 3, 4, and 5 of column 7A3, I have invested in share equity in Metro Builders Odisha so and so, so and so, so and so. It is also a fact that the amount reflected in serial number 1, 2, 3, my spouse Firdosa Bano has invested in share equity so and so, so and so. Then it's a fact that the companies in which I and my spouse have made investment in share equity as reflected in column are private company and not listed in a stock exchange. It's a fact that though it was required to disclose the book value of investment in shares in case of non-listed companies as per column so and so, as per advice given by chartered accountant, I reflected the figures as share equity in different private companies. In respect of me as well as my spouse so and so, I know what is book value of share. I cannot say whether amount reflected in so and so are the book value of the shares or not. Then it is not a fact. I gave suggestion.
Sir, say nije
and regarding LIC policy, your lordship kindly see page 68, para 89. It is a fact that as per column 5 of column 7A of the affidavit, a candidate has to furnish the details, include the amount separately in respect of each investment. It is a fact that as per note 2 of column 7 of the affidavit in form 26, a candidate has to furnish in case of deposit investment the details including serial number, amount, date of deposit, the scheme, the name of the bank branch. It is a fact that in column 7A4, affidavit in form 26, while giving the details of investment of LIC policy number so and so and so and so, I mentioned the date of policy and period of policy and its surrender. There is no mention of period of policy, Milo. However, I have not indicated the amount of investment and scheme of LIC policy in which investments have been made. Then he himself volunteers, my lord. Since I furnished the surrender value of the aforesaid two policies and the maturity value had already been credited to my account, I did not think it was further necessary on my part to furnish the amount on investment and the scheme. If, my lord, the policy was matured, then no policy was pending on the day. Then again he says, the witness again says that he is not sure whether the maturity value had already been credited or to his account or not.
He's taking a vacillating stand, Manoj.
Hmm.
যদি আগে
Once it is matured, it will automatically go to the account.
Account.
Of that
account
right.
ତାପରେ ସେ policy ହିଁ ରହିବନି
Obviously.
policy ସେ ଲେଖୁଛନ୍ତି and he himself says I have not reflected the investment as per the requirement. He says I have reflected the surrender value. अब ये जो equity share है, he himself says I have reflected the equity shares, not the book value.
Okay, you mean to say that such type of information which is given creates confusion in the mind of
misleading and false.
And it is not as per the requirements of Form 26. It has to be in accordance with the requirements of mandate of Form 26.
Okay. Next.
तापरे आओ सर इतने आओ किसी
अब next one.
Next वाला
investment वाला ये वाला criminal वाला
immovable property.
Immovable property, issues number 28.
Issue number
28, 29, 30, 31 and 32. तापरे सर एटा हला relating the immovable property. एगुरा हला सर movable investment and this is immovable.
I'm a petition pleading.
I'm a petition रे हमें plead करछु 7E page 14 fifth line from the bottom that the respondent has declared about non-agricultural land. The respondent has declared about Moza Unit 13 Chandni Chowk, Khata number 799, plot number 220 and 221, but there is no plot 221 in Khata 799 as per ROR downloaded from the official website, that is Bhulek. The election petitioner in his evidence states, page 18.
Para 25.
Para 25. Have you jawab dala that these are out and out false and fabricated?
Election petition.
Evidence on affidavit. Exhibit 36.
Evidence on affidavit by the respondent.
By the election petitioner.
Election petitioner.
Se bhi etar jawab ଦେଇଛନ୍ତି ଆଜ୍ଞା ମାନେ in the written statement these are fabricated concocted statements. Election petitioner page 18 रे कहले para 25 that the respondent has further declared that he is the owner of Moza Unit 13 Chandni Chowk, Khata number 799, plot number 220 and 221. But plot number 221 has not been recorded in Khata number 799 as per certified copy of the ROR filed and exhibit as marked as Exhibit 5. Further, one Izar Ali is the recorded owner of the said Khata number 799, plot number 220 only. Similarly, the area of plot number 220 and 221 have not been declared or described separately by the respondent in his affidavit filed in Form 26.
Cross-examination.
Cross-examination re the election petitioner file at page 39, para 84. Lordship gets it.
84. ठीक है para 84 तो
आ गया
page 39 cross examination para 84
कहारो इरा
election petitioner
election petitioner इटा तो evidence affidavit ता तर बात करो सिर्फ
evidence affidavit तळे थबा cross examination
एटा होची बोधे रेस्पोंडेंट हम जोड़ा बाहर कर दो एटा प्रथमटा एविडेंस एफिडेविट ता तळे जेरा आइची चीफ हेगिन जेरा आई केते पेस्ट आउथर कोन
सर
page 39 para 84
कोन
The copy of the ROR which has been downloaded by me on 28/6/22 at 3:40 p.m. relating to Moza unit number 13 Chandni Chowk, khata number 799 indicates there is one plot 220 under the said khata. The downloaded copy of the khata is marked as Exhibit K. There is no plot number 221 in it.
The certified copy
Then the certified copy of the ROR in respect of the aforesaid Mozart number 13 has been marked as Exhibit 5 was obtained by me on 7/7/2022. Election petition was filed on 3/7/2019.
Then examination in chief,
Respondent in his examination in chief,
page 45.
page 45 at page, para 45 at page 6.
Para 45, page 6 में था.
पेज पारा 45
para 45 page
पेज 9 लिखा है जी
page भूल है
पेज टा भूल
ମୁଁ କହିଛି.
अच्छा
chief दिया तो chief para 45 एक मिनट.
चीफ एग्जामिनेशन 27 पृष्ठार आरंभ ହେଇଛି ସେଟା ଭୁଲରେ
page 98.
Page 98 रे आ गया. सब para, third sub para. Page 9.
Evidence.
Evidence.
Page 97 started.
Page 97 रो last para रो देखिए.
Started.
it is a fact that against item number 3
page 97 रो last paragraph.
हाँ it's a fact against item number 3 पर ये लिखा है जी.
No. Though the election petitioner has alleged.
Examination in chief.
Examination in chief.
Evidence on affidavit.
Evidence on affidavit.
Page 97.
देवासी समुद्राय तो
नहीं RW1.
RW. 97.
Sir.
Though the election petitioner
has alleged that there is no plot number 221 in khata number 799 in Moza unit 13 Chandni Chowk, he has not mentioned disclosed the correct khata number under which plot number 221 comes, nor the election petitioner has adduced any documentary evidence in that respect. However, the election petitioner has produced the certified copy of ROR of khata number 799, Moza unit 13 Chandni Chowk, and the same has already been marked as Exhibit 5. That under column 7B2 of the affidavit in form 26, every candidate is required to furnish information about non-agricultural land location survey numbers, which I have mentioned correctly with respect to my property situated in district Cuttack, Moza unit 13 Chandni Chowk, khata number 799, plot number 220-221. Again he says 220. I have mentioned the location of the property correctly, and I have also mentioned survey numbers, that is plot numbers of the property correctly. Under column 7B2, there is no instruction to give khata number of the property.
Survey number khata number.
Again, unless the survey number khata number no dela, how can the exact location of the plot be known? Survey number jota indicate korchanti, that includes the khata number. Then I have purchased a compact area of 0.017 decimals, that is 0.013 from plot number 220 under khata number 799, out of its total area 0.130 decimal and 0.004 decimals from plot number 221 under khata number 48, out of which its total area, the last line, I have furnished all the required information with respect to the said property in my affidavit in form 26. Exhibit 43, 43, 44.
Cross-examination
Cross examination रे से कहले
at page 73,
page 73,
para 93.
para 93.
73 page.
Cross-examination.
Cross
Oh,
examination.
page hochi
73, para 93.
para 93.
Exhibit
Exhibit EH.
EH. The certified copy of the registered sale deed bearing 3458 dated 11/4/2011 indicates that I have purchased 2 plots and one of such plots appertains to Khata 48, plot number 221, area 0.014 decimals. It is a fact that in column number 7B2, serial number 2, under the heading of non-agricultural land, I have omitted to mention Khata number 48, though I have mentioned plot number 221, which was purchased by me while exhibit EH. It is not a fact that I have deliberately suppressed to mention Khata number 48 to mislead the voters. So he was under obligation to because survey number, my lords, once he is to give, he has to give everything, all the details correctly. Again, 48 plot khata number not dele, how will this plot be identified? So he himself admits, yeah, I have omitted to give khata number 48. It was not necessary to mention khata number 48 at all. This is his own interpretation of the mandate of the of Form 26. Proper, sir.
Clause लिखेंगे नोट देगा अच्छी ये 78 para 100 ये प्रॉब्लम को लिखेगा para 100
It was a city shell.
सिटी फ्लैट ऑफ आई पे जो उठाई लिखो
सर आउ गोटा जगह रे गोटा सिटी शेल्टर गोटा सर रेजिडेंशियल कॉम्प्लेक्स अछि he has purchased plot number 05/E.
Just a minute.
He has purchased a flat in that city shelter complex 05/E. But CA disclose color.
F5.
If your lordship sees
exhibit 43 page
exhibit 43 page 17.
43. Hmm. 43 page 17.
Page 17. Column 4 residential buildings. Serial number 1 re last sir देखिए.
City shelter the.
City shelter district Mauja Kattak town unit number plot number ground floor flat numbers 1A 2B F by 5. But the exhibit the certified copy of sale deed it is E by 5 by E.
05/E. So he is disclosing another flat number 7
F5.
F by 5. Which is a completely different. It may be a flat there, may not be a flat there. And if it is a flat, it might be a 4-bedroom flat. This might be a 1-bedroom flat. So he has not given correct, my lord's disclosure of his property by giving a false. My lords, in his cross-examination, again he comes up with that same explanation. These are typographical errors. It is a fact that the property described in the sale deed dated wide that is paragraph 100, has been reflected under Schedule B of the sale deed to be flat number 05E, situated in the ground floor of multi-story building of the complex in the name and style of City Shelter. But while mentioning the property in column 7.B4 under the heading of residential buildings, including apartment, I have mentioned flat number to be F by 5 inadvertently, so far as my column is concerned, and in the column of my spouse, the flat number has been mentioned to be 05. And such mistakes are typographical. It is not a fact that deliberately I have made a false declaration by mentioning wrong flat number of City Shelter in my affidavit in Form 26. तापर सर
Exhibit 43. Purchase price of self-acquired. Purchase not Exhibit 43, page 23, my lord. Affidavit in form. Your lordship may turn to the page 24. Top one. Purchase price of self-acquired immovable property. He declared himself purchase price, my lord. But in his spouse column, he writes not applicable. If your lordship looks to the part A of this affidavit, my lord, total amount he purchased, he has declared at page 15, at page 15,
50 माने कौन
15 सही exhibitor. Part A रे individually देबे आगे 10टा property नेले को property केते टंका रे किनिले. Part B रे total consolidate करिकि देबे total मु एतिकी टंका रे property किनिछि. Page 15 रे से column 2 ता निजर देइछन ठीक wife रो but 38,000 10,000. Then the next page, investment by way of development construction 3 lakh. Current market price 1 crore 82 lakh 50,000. 16 lakh 10,000. Then regarding column 3 has given purchase price at page 17 million. Of his spouse 20 lakh 51,844. And current market price is 126.48. Then the next page, page 18 million. Last. Cost of property in case of purchase 11 lakh 11,360, 5 lakh 62,750, 17 lakh 41,414. Next page 2 lakh 86,650, 1 lakh 10,017. Construction ta tolo column re construction serial 4 re lekhile 10 lakh टंका invest करचंती. Approximate market price देइचंती. If your lordship looks to that page 24 in part B consolidated करिकि देबे. He has written not applicable, not applicable, not applicable.
He should have disclosed the entire purchase price along with investment and other things, development cost and other things of his wife. Admittedly, Nijjara dele kintu his wife he has not disclosed.
This amounts to suppression.
This amounts to suppression, Manoj, and false declaration.
Yes.
This is also his explanation is, Manoj, ame examination in chief re koichu. से तांकर क्रॉस एग्जामिनेशन रे कहिले चीफ रे कहिले Page 108. Page 108. Evidence on appeal. Lordship gets it.
Which page?
108.
108.
Last subpara.
The further allegation.
In the format of the affidavit in Form 26, there are Part A and Part B.
এটা ইয়ে পর্যন্ত রেসপন্ডেন্ট নম্বর
Respondent ro examination in chief.
Further allegation.
এইটা কোন
Page 108. Evidence affidavit.
মোহাম্মদ মুকিম কর RW
Exhibit DW.
পেজ নম্বর ହେଲା
108.
আরে সেটা যেটা বাহার করছিল সেটা বাহার করো। 108 କୁ କୁଆଡେ ସେୟାର କରିପାରିବନି।
The further
108. It's a fact that
Subparameter top. The further allegation.
Further allegation of the election petitioner is to the effect that in column 11 of part B of the affidavit, I am required to declare the abstract of the details given in 1 to 10 of part A.
পেজ কেতে পড়ুଛନ୍ତି?
Page 108.
108 second paragraph. মানে
Just
first paragraph जोड़ा further allegation.
Subpara 103 ପରେ କାହିଁକି? 103 ରେ ସରିଛି ପରା ସେଟା?
ନାଇଁ ନାଇଁ ତାଙ୍କର ଏଭିଡେନ୍ସ ଆଫିଡେଭିଟ୍ 128 ପେଜରେ ଅଛି। ଏଭିଡେନ୍ସ ଆଫିଡେଭିଟ୍
मोहम्मद मुकीम से देखो ना कि कहाँ रहता एविडेंस
एग्जिबिट DW 103 रा क्रॉस एग्जाम से एकदम ऊपर था तारी दे सौ आठ ସେଇଟା
ଆଜି କୋର୍ସ ସରିବ ସବୁ ତକ ଭେରିଫାଏ ହବ ହେଲା ଯୋଉଟା ସ୍କାନିଂ ନ ହେଇଛି ସ୍କାନିଂ କରି କମ୍ପ୍ଲିଟ କରି ତା ଦେହରେ ଠିକ ସେ ପୁରେଇବ ହେଲା।
First subpara. Further allegation.
ସମସ୍ତଙ୍କୁ ରଖିଥିବ କାହାକୁ ଘରକୁ ଛାଡିବନି ମୁଁ ବୁଝିବି ରାତି 8:30 ବେଳେ ଫୋନ କରିବି। Yes.
The further allegation of the election petitioner is to the effect that in column 11 of part B of the affidavit, I am required to declare the abstract of the details given in 1 to 10 of part A, and in column 8/1, I am to declare the purchase price of self-acquired immovable properties of mine and my spouse. I, while declaring the purchase price of self-acquired immovable property of my spouse, have declared not applicable. I have not declared the purchase price of the self-acquired properties by my spouse. I have also not declared the development construction cost of immovable property after purchase by my spouse. I have also not declared in part B, column 8.3 about the approximate current and the total value of self-acquired assets of my spouse. In the format of the affidavit in Form 26, there are Part A and B. Part A consists of column 1 to 10 and column 11 is Part B itself, which consists of column 1 to 11. In the column number 11 of Part B, in the format of the affidavit in Form 26, under the heading highest educational qualification, every candidate is required to give information regarding his educational qualification. This goes on to educational qualification. My lords, then he says, page 109. Since last subpara explanation देची. Since I have furnished all the required information in detail with respect to immovable assets of my spouse in column 7B, wide its serial number 1 to 4 under part A of my affidavit in form 26.
1 to 6.
1 to 6 under part A of my affidavit in form 26, as well as total value of immovable assets of my spouse in column number part B of my affidavit in form 26, mentioning of not applicable inadvertently under the name of my spouse against columns number 8B1, 2, 8B2 and 8B3 of part B of my affidavit in form 26 does not create any serious confusion in the minds of the electorate of 90 Barabati Cuttack Assembly constituency, and the same cannot be said to be suppression of information. He admits this fact. He admits he has not given information as mandated by Form 26. But he says it will not create that. This is the explanation. Is he to be the judge of his own cause, my lords? What will create confusion? What will not create confusion? The commission has mandated this has to be given. Commission in its wisdom, in pursuance of various directions of the Supreme Court, because, my lords, aggrandizement of wealth is also one of the factors the Supreme Court has consistently been worried about, my lords. My lords, what is happening, my lords? Even if the elected candidate himself does not become rich, suddenly you find his son has become a multimillionaire, his wife has become a multimillionaire, his granddaughter has become a multimillionaire. So that is why exactly all these details are necessary for the public to know. And law requires a thing to be done in a particular manner. Can he say, no, this will not create a confusion, my lords? Once law requires a thing to be done in a particular manner, it has to be done in that manner or not at all.
And cross-examination.
And then in the cross-examination,
Page 84.
Page 84.
Para 105.
Para 105.
Who page to Xerox you scanning in? Huh? 103 evidence sorry जी 120 के तेरे
128
सब गुड़ा का चेक करियो हैला yes which page
Malot's page 84 paragraph 105 cross examination Lordship gets it.
Yes.
It is a fact that in part B of my affidavit in form 26, exhibit 43 in column 8B1, under the heading of purchase price of self-acquired immovable property, column 8B2, 8B11, under the heading of development construction cost of immovable property after
page
purchase.
84 ko lebra
Page 84, paragraph 105.
Cross examination.
Cross examination.
Seita age chief apano pakre. Cross tale thabo. 128 page pore. Cross examination, page 84, para 105.
Again, it is a fact that in part B of my affidavit in form 26, exhibit 43 in column 8B1, under the heading of purchase price of self-acquired immovable property, 8B11, under the heading of development construction cost of immovable property after purchase if applicable, and column B3, under the heading of approximate current market price of a self-acquired asset.
Another যেহেতু এটা কোন ହେଇଛି ନା evidence affidavit रे तापर सेटा पेज नंबर कंटिन्यू करनी माने जोटी क्रॉस एग्जामिनेशन आरंभ ହେଇଛି सॉरी आपनकर चीफ एग्जामिनेशन आरंभ ହେଇଛି
1 ରୁ
आरंभ ହେଇଯାଇଛି तेणु आपण
नहीं क्रॉस एग्जामिनेशन एट पेज
खाली सेति लगदे
चीफ एते पेज क्रॉस एग्जामिनेशन एते पारा एते
नाले कंफ्यूजिंग है
खाली पेज नंबर
नहीं।
देले एटा whether chief
No,
रो
no.
ये की
Free page एते पारा एते
हाँ,
cross page एते पारा एते.
ठीक ठीक. Yes, continue.
It is a fact that in para B of my affidavit, part B of my affidavit in form 26, exhibit 43, column 8B1, under the heading of purchase price of self-acquired immovable property, column 8B2, under the heading of development construction cost of immovable property after purchase if applicable, and 8B3, under the heading of approximate current market price of self-acquired assets, total value and inherited assets total value. I have mentioned the purchase price, development, construction cost, approximate current market price of my self-acquired immovable property. But so far as my spouse is concerned, I have mentioned as not applicable. Since I have mentioned in part A, column 7B, 2, 3, and 4 of my affidavit in form 26 regarding the purchase price
Similar
of the land,
answer has been given. That
same answer has been
Sethi
given.
mention कर दीजिए तो
And it's a clerical error.
And again he says it's a clerical error.
Hmm.
Matlab, his entire affidavit is one giant typographical and clerical error. Approximate current market price with respect to my spouse, I did not mention it in part B of my affidavit in form 26 in 8B 1, 2 and 3. Such omissions are clerical errors. It is not a fact that it was not a clerical error on my part to omit in mentioning the purchase price of the self-acquired immovable property, development, construction cost, approximate current. Sir, एगुड़ा फिर continues. And then we have put question जे voter cannot know. Next question is, it is put to you, the voter cannot know what is the purchase price of your property. So, it is chalchi, we will quote it in our.
ସେମିତି ଆଉ property ଆମେ ଦେଇଦେବା detail.
So, ସେମିତି ସବୁ property ର ସେ
ଖାଲି ଗୋଟେ important.
ଖାଲି ଗୋଟେ sir ଆମେ ଦଉଛୁ, ଅଲଗା ଗୁରା ବି ସେମିତି he has ସବୁଥିରେ ସେ କହୁଛନ୍ତି clerical mistake, typographical error.
ଏଇଟା exhibit 43
Exhibit 43,
page 18.
page 18.
The evidence of reproduction cross examination.
ये जो आंसर टा ଦେଇଛନ୍ତି
Sir.
ये जो page 88 ये cross examination में to your question which is put in page number 87 ठीक है देखिला last question 108 रो जो paragraph रे जो question टा पचरा है जी
Whether in exhibit BL, CD, CU and DL any instruction was given by the RO এটা regarding that exhibit जो xerox copy जो
सही सर तर आंसर टा से जो ଦେଇଛନ୍ତି
while the xerox attested true copy of the revised affidavit in form 26 there was no specific instruction to file the revised affidavit all in original.
हाँ सही बता
If your lordship have to read section 33A, my lord. Kind your lordship see section 33A.
मतलब लिखा है कि चारिटा जाको सेट रे ओरिजिनल एफिडेविट
क्या आगे 33A देखो तो आरपीएफ
इसे आंसर तो देखें से इतना पचेबल ए थोड़ा लगा
Hmm. 33A. A candidate shall, apart from any information which he is required to furnish under this act or the rules made thereunder, in his nomination paper delivered under subsection 1 of section 33 form 2 be a nomination dabo. So and so. Then 2. The candidate or his proposer, as the case may be, shall at the time of delivering to the returning officer the nomination paper under subsection 1 of section 33 also delivered to him an affidavit shown by the candidate in a prescribed form verifying the information specified in subsection 1.
affidavit টা
এটা পুরা ফর্ম এটা দেব affidavit the candidate or his proposer as the case may be
ସେ ରିଭାଇଜ୍ଡ affidavit ଟା କରେ କାରଣ affidavit ଟା ସେ ତ original ଟା ଦେଇଥିଲେ ଯୋଉଟା କି ତାଙ୍କ କେସ୍ ହଉଛି ମାନେ ତାକୁ ଇଏ କରିବା
ଆଜ୍ଞା original ତ ଯୋଉ ଦେଇଥିଲେ original ଯୋଉ ତାଙ୍କ କେସ୍ 2 ତାରିଖର ନାହିଁ ଆଉ 3 ତାରିଖ affidavit. So he is to file, if he files 4 nomination paper, he is to file 4 affidavit. So along with the nomination paper, he is to file an affidavit. Se revise diyantu ki gotiye deithanta jodi. Not that ki gotiye original daba 3टा xerox daba.
ଗୋଟେ xerox ରେ suppose he gives a false information on a xerox affidavit. ଗୋଟେ original affidavit ଅଛି, he gives a false information in a xerox. ସେଇ affidavit ଟା carry forward ହେଇଛି. ସେ xerox affidavit ଉପରେ he also can be prosecuted.
ଲେଖା ହେଇଛି ଯେ
attested true copy ଲେଖା ହେଇଛି.
Attested true copy ଯେ an affidavit. What is an affidavit? Can it be a xerox copy of an affidavit?
Your Lordship also see kindly Rule 4A. Rule 4A of Conduct of Election Rules.
Affidavit.
Rule 4A.
A of Conduct of Election Rules 1961.
Form of affidavit to be
Form of affidavit to be filed at the time of delivering. The candidate or his proposer, as the case may be, shall at the time of delivering to the returning officer the nomination paper under subsection 1 of section 33 of the Act, also deliver to him an affidavit shown by the candidate before a magistrate or the first class or notary informed on it. It's not.
He means to say that it would apply, not to apply to perhaps the revised affidavit.
Again, যদি affidavit দেই নথান no. যদি affidavit not দেবে, the nomination is to be rejected for non-compliance of section 33A. So he has to give an affidavit.
Revised affidavit ସବୁ ଗୁଡାକ in original ଯାହା କହୁଛି ସେ ଆଧାରଟା ଏ page 88 ରେ there is no specific instruction to file revised affidavit.
ସେ ଯେହେତୁ checklist ରେ specific ଦେଇନି ଗଲେ ଆର ମତେ specific instruction ଦେଇନି to file. ସେ ସେତେବେଳେ ଆଜ୍ଞା ଯେହେତୁ original ଦେଇଥିଲେ ଆର କହିଲା file revised affidavit. In fall is asked them to file
earlier affidavit.
Plain affidavits were original, my lord. So RO said file revised affidavit. যদি আগে xerox ହେଇଥାନ୍ତା RO might have said file on stamp paper original. First plain paper affidavits are in original, all four.
All four.
All four are original.
All four are in original.
Okay. Yes, anything else?
Only one property, my lord. बाकी जहाँ अच्छी मु दे देबे और छोटिया छोटिया अच्छी. Your lordship kindly see page 18 of exhibit 43.
ଏଇଟା ରଖ.
ମୁଁ କହି ଦଉଛି ନହେଲେ ନୋଟ୍ସ ଲେଖା ଚାରିଟା ହେଲାଣି. ଏଥିରେ ସେ କହିଲେ ଆଜ୍ଞା ଡିଷ୍ଟ୍ରିକ୍ଟ ଖୋର୍ଦ୍ଧା ମୌଜା ରୁଦ୍ରପୁରରେ ଗୋଟେ ଫ୍ଲାଟ୍ ଅଛି ତାଙ୍କର A108. He exhibited certified copy of the sale deed purchase of that land he has purchased. Page 101. Examination in chief रे आज्ञा से पेज 119 रे कहिले
କାହାର evidence place କରୁଛନ୍ତି?
ये जो respondent हो
नहीं ସେଟା ନାହିଁ ଦିଅ.
Then your lordship may states look to that cross examination.
It is scanning in
78 para 101. 78. Cross-examination.
पेन ड्राइव रे मते जो देइथिले इंटर रेकॉर्ड ता देरे भी सेटा अमेंडमेंट माने करेक्शन एटा बुझिपाइलो ना सब गुडा रे चेक करियो
Next.
सब जेतिक एग्जिबिट जेतिक सब पेज गुडा अछि ना इन फुल कारण 104 हे चिरा इटा yeah
Para 101, page 78, my lord. Bottom. It is not a fact that this sale deed he exhibited. That sale deed and exhibit EZ myself and one Piyush Dhari Mahanti purchased the property mentioned under the heading of description of schedule of the property. The particular property was developed, he has given expiry developed by the company, but there was no document. But registered sale deed is in his paper and one Piyush Dhari Mahanti's paper. Then your lordship may turn to the next page, my lord. Here says I am not the owner of I have not purchased that property. Para 102. It is a fact that I mentioned in my evidence on affidavit in para 28, page 11, that after completion of project, namely metro satellite city over the purchased land, purchased land. At Mauja Rudrapur, I as well as Piyush Dhari Mahanti sold out the flats units to our customers, whereas I kept one flat number so and so, first floor for me. I have not purchased flat number so and so, first floor metro, but I got the flat in lieu of my land given to the company for development. So company ko kemiti there was no document. Rather, they exhibited the sale deed where this property has been purchased by him and one Piyush Dhari Mahanti jointly. कॉन्ट्रैक्ट कहले अब से फ्लैट कंपनी देला से विषय भी कौन सी डॉक्यूमेंट नहीं क्वेश्चन योर लॉर्डशिप में सी पेज 81 whether such a document executed by the company on 31/7/2000 was required to be registered or not. According to me, it is not as my lord, if your lordship sees the registration act, property more than 100 rupees can right titled interest of a property more than 100 rupees cannot be transferred without registered sale deed. Here, the next exhibit EZ is the sale deed in respect of the property of Mauja Rudrapur, khata number so and so, plot number so and so, area acre 3.13 decimal, which was purchased by me and Piyush Dhari Mahanti jointly. In para 101, he said, I have not purchased that property. It is not a fact that I have told falsehood on 12/9/23 before this court on oath at paragraph 101 of my cross-examination that under the sale deed exhibit EZ, myself and one Piyush Dhari Mahanti did not purchase the property. Then it is a fact that Santilata Prusti and 4 others executed general power of attorney while exhibit EY in my favor as the managing director of Metro Builders Odisha Private Limited in respect of the property of Mauja Rudrapur, khata number so and so, area so and so. As the managing director Metro Builder, I executed the sale deed in my favor as well as in favor of Piyush Dhari. Yada कहउछन्ति कंपनी आगे डेवलप कला. So Nijja as a managing director of the power of attorney holder of the original owner, he himself executed and registered the sale deed in his own favor and in favor of one Piyush Dhari Mahanti. Then next page, my lord, after the 6th line, it is a fact that I have omitted to mention in my evidence affidavit at page 118 first subpara as well as in my examination at page 12 that the registered power of attorney while exhibit EY was executed in my favor in the capacity of managing director Metro Builders Odisha Private Limited. It's not a fact that I have stated falsehood in my evidence on affidavit as well as in my examination in chief in that respect. It is a fact that I have omitted to mention in my evidence affidavit at page 118 second subpara as well as in my examination in chief at page 12 that the registered sale deed wide exhibit EZ was executed by me in the capacity of managing director Metro Builders Private. It is not the fact that I have stated falsehood so and so. Then your lordship may kindly see page 1, para 104. We obtained, my lord, the encumbrance certificate from the sub-register. We confronted him. Please look to the exhibit 48, which reveals that in Mauja Rudrapur Khata number so and so by date of filing of a nomination paper on so and so, several transactions have been made in respect of this property, and some flats were transferred in favor of different persons by you. And whatever the balance landed property is available with you as per the said certificate, or on the date of filing, you have not correctly reflected the same in your affidavit. Except flat number so and so in the first floor metro satellite, the rest of the flats of Mauja Rudrapur had already been transferred. But if your lordship looks to the exhibit 48, there is no transaction. Even on the date we exhibited below, just one day prior to that, till 2023, except some transaction, there was other part of the property was there in their name. In this way, my lord, this affidavit has been in form 26 has been filed. I'll give detail in my note, my lord, which amounts to suppression and false declaration. Here, the respondent has not filed his nomination paper in Form 2B in the prescribed form. He has violated the mandate of Section 33, read with Rule 4 of the Conduct of Election Rules 1961. He has also violated the mandate of Section 33A, 4A of the Conduct of Election Rules 1961. He has suppressed his criminal antecedent in his affidavit in Form 26. He has also not disclosed the correct details of his movable properties and immovable properties. In view of this, my lord, his election is to be declared void, and the RO has illegally and improperly accepted his nomination paper. And we have placed, my lord, on record his judgments. Once it is alleged that the nomination paper of the written candidate has been illegally and improperly accepted, and once your lordship holds that he has violated the mandate of RP Act, there is no, though we have pleaded, there is no need and prove the result of the election has been materially affected or not.
And your judgment will revert back to the date of original acceptance. Your lordship's judgment will revert back to the date of original acceptance. Another point that my learned friend has left out is that an affidavit dated 3rd has been given. So that cannot be accepted as an affidavit in the ISA. So we'll give a detailed note. And my lord, the entire affidavit which he has given, everywhere he says, he admits mistakes have been committed, these facts have not been stated, there has been suppression of facts. And all that he says are those 3 answers, top 3 answers: typographical error, clerical error.
Can the court now ask the learned counsel for the respondent to say about that? My advocates can reply so that they.
Advocates, Mr. Taradipal will.
You'll be examined as court witness. All right. So you finished one day prior to your commitment. That's good. Mr. Mishra will start from 22nd or 24th.
I will start. I will give reply on 25th, 29th, 30th, 31st.
Okay. Your ends on 31st. Or 25th.
So the case may be called on
25th. Mr. Milan Kanungo and Mr. Agrawal concluded the argument from the side of the election petitioner. Okay. Mr. Mishra submitted that he will give his reply as per the order dated order pass on from 25th January 2024 onward. Put up this matter on 25th at 2 p.m. फाइल भी केप सेटा लिखि दे फाइल भी केप जे आगे स्कैनिंग करिवो जोडा थेन तापरे फाइल भी केप ऑल राइट मिस्टर
Obliged for us. Really obliged for such a patient hearing.
it may not be possible to take off all these matters. I'll take a few and then the rest of the matter will be listed on Monday. That will you are available. Which is your item?
I'll do it on VC. Otherwise, my lord, I should be available, my lord, on Tuesday, Tuesday and Monday night. I'll have to go.
You are not going to Ajodhya.
Well, unfortunately, I met Ajodhya today in the
There was
court.
some proposal given, so I thought that.
My lord, I had an invite, but I didn't want to go.
Yes,
21st.
No, I propose to the entire list will come on 22nd.
Yes.
If somebody is not available on that day, you can say so that accordingly it will be listed on other day. If any Law and Council of this list, today's supplementary list, is not available on 22nd, just indicate to the court masters, also the Land and State Council, so that it will not be listed on 22nd, but on the other day. Otherwise, the entire list will come on 22nd. That would be ଆପଣ କହିଲି ପରା ଆପଣ ଯୋଉଟା ଆପଣ ଯଦି 22 ତାରିଖରେ ଚାହୁଁନାହାନ୍ତି ତାହେଲେ ଆପଣ indicate କରିଦେବେ otherwise ସବୁତକ matter 22 ତାରିଖରେ ଆସିବ.
I just want to have a caveat in that matter item 20. There are, I think, 7 other matters, but this is one matter where that man has been in custody for multiple FIRs for the last 5 years.
20 ରେ ପରା କହିଲି
I want to give a list, my lord, of the other matters where notice had been issued, but they have not been listed.
No, because again those cases have to be traced out because you.
No, they were together at one time.
Okay.
It might, I don't know why it has missed. They've come together.
It is possible. List it with
They've come together.
All these matters will come on Monday.
Yes,
There is the interim order, my lord, in view of this.
Wherever interim order is there, it will be. जोड़ा करे verify कर दो interim order जोड़ा अच्छी से दे दे है ना anticipatory bail matter
Regular bail matter. Regular bail लाला
अच्छा वो regular bail हाँ से जो ये लाला सागर राय है ना खाली रखी दो on Monday interim orders केवल सही केस रो केवल लाला अमृत सागर राय पाई interim order है जी
14, 15, 16, 17
से गुड़ा को केवल सेती extend करिवो बाकी सब तो आसीबो सोमवार दिन
item 4 is interim order extract
कहली परा जो interim order अच्छी just indicate so that it will be extended till Monday.
Item 7 bail matter is
it will come on Monday.
If you
have
pre-lunch, if possible,
if you have got any difficulty on Monday it will be taken off right from 2 o'clock because the election petition is, so the list will be there. If you are not available on Monday, then give your suitable date so that it can be listed on that. I'm giving the liberty. Any date you feel convenient, give it. Otherwise, it will come on Monday 22nd. Okay.
Yes.